Welcome to GAR Interactive Damages. I am David Samuels, publisher of GAR. And before we get properly underway, I'm just going to say a few housekeeping sort of messages to make the afternoon, morning, wherever you are, go smoothly. You've seen a film that gives you a little bit of sort of the check-in procedure. I'll expand upon it very briefly. We would invite you to change your name using the three dots at the top of your rectangle. If you right-click on that, you can put in whatever your name should be rather than sort of Delos webinar or something that Zoom may have you down for from a past thing. And that should make networking and things easier. We are coming to you as GAR Interactive today. Of course, normally we come to you as GAR Live, but we are not live. We discussed what we should call ourselves, and there are some sort of funny things to be said about sort of GAR at home or GAR not live. But actually, interactive is quite a good name for what we do. We found that the virtual version of our events does allow people to join in far more easily from the audience than maybe the real life version does. And we would encourage everybody to take maximum advantage of that. I see that we've got a very gratifying number of people already with us. And I hope that some of you will chime in with your thoughts on chat, talk to each other in private messages, and just sort of generally enjoy the time away from the regular grind of work. I know that I find these events a fabulous break from the relief of sort of relentless internal meetings and Zoom calls that I don't want to be on. And it's nice to sort of see so many friendly faces and get a chance to catch up with them. So I've mentioned changing your names. I've mentioned the interactive aspect. Please think of the GAR sort of team members, myself and Erica and Grace, as your sort of concierges. And if there are any issues, don't hesitate to drop us a quick private message and we'll try and ride to the rescue. We find actually everything goes really rather smoothly these days. You're in safe hands. We've done a lot of these events. We will move you around to where you need to be without you having to do anything. Literally, the only thing that you could do that would be wrong would be to leave the meeting. So I encourage you not to leave the meeting until you definitely want to do that. Other than that, it just remains for me to say a huge thank you to our sponsors who you saw on the screen at the beginning, without whom this really wouldn't have been possible, to our fabulous speakers who've all said yes to the time slots. And we're delighted to put them on for you. And we're thankful to them for saying yes to the invite. And to our stalwart chairs, Alex and John Trenner, who, as they always do, have put in a real shift thinking through what we should talk about and who we should invite. We should just get on with it. I'm looking forward to it. Chairs, over to you to get us underway properly. See you later.
Thank you, David. I'm John Trenner. Good morning, good afternoon, good evening, whatever time zone you may be in. I'm a partner in the International Arbitration Group at WilmerHale, and I'm chairing with Alexander Demuth, who is an expert at Alvarez and Marsal. And welcome to what I believe is the fourth almost annual GAR Live, GAR Interactive event focused on damages. And as David said, the first one done virtually. This event today coincides with GAR's launch of the fourth edition of the GAR book, The Guide to Damages in International Arbitration. And the objective of that book is very similar to the objective of today's event, which is to help all participants in the international arbitration community, from the users, the clients, the parties to international arbitration, to their counsel, experts, and to the deciding those issues, to understand damages more clearly, to help communicate those issues more effectively to tribunals, to further the common objective of assisting those arbitrators in rendering more accurate and well-reasoned awards on damages. And the fourth edition of the book is a thorough kind of reworking of the publication with new chapters, revised chapters. And we focused on this edition on the inclusion of visuals, charts, graphs, worked out examples, case studies, flowcharts, checklists that can help the users understand the various damages issues in the book. And the book covers a lot of the issues we're going to address in more detail. And as always, we encourage comments on the book. You can send those either to me or directly to GAR, reactions to the book, ideas for future chapters. We have a busy program today with 3 substantive panels and several networking sessions in between. And with that, I'll turn it over to Alexander to talk a little about today's event.
Thank you, John. And first and foremost, welcome everybody to GAR Interactive, also on my behalf. As much as I would have loved to welcome you in person, I think the interactive solution is the best that is available as of today. And I'm thankful for GAR pushing the event. We've been pushing it and postponing it for quite some time, hoping for improvement and the ability to meet you in person. But this is obviously the best current possibility. Obviously, as John mentioned, being an expert in damages, today's sessions are very dear to my heart, and I'm much looking forward to hearing from the esteemed panelists with their wealth of experience covering these aspects in submissions and hearings from the arbiters' tribunal's perspective, as well as from counsel's perspectives and experts' perspectives, what else we need to do, where we can improve, and how we can make things easier for everybody in this society. Today's program, as John already mentioned, is centered around 3 panels. And the first is looking from the arbitrator's perspective and trying to establish what lawyers and experts could do better. After that, I learned we have a networking breakout session. I understand you will be randomly appointed to breakout rooms. You just click join, and then you meet some interesting people. I'm pretty sure you will have a nice conversation, and we will have to disturb and interrupt you to bring you back to our second panel, which is then on counsels and experts and their expectations and hope from arbitrators in proceedings with regards to damages. And our last but not least panel will be a question time, where we do have some questions that have been pre-submitted by participants, but we encourage each and every one of you to make use of what you've heard today and formulate your questions that may arise during today's sessions. Thereafter, we will have some very brief closing remarks, at least that's our usual procedure. And then there is a networking event for which I think there's going to be some more announcement from David later on. Over to you, John.
Thank you. Let me just add on questions. As David mentioned, there is the chat function, and we have a whole session devoted to questions, but there may be an opportunity during the other panels for the panelists to address questions if we're fortunate to have that time. So with that, I think we are going to start our first panel, what arbitrators want from lawyers and experts. And let me briefly introduce our 4 panelists. We're very fortunate and thankful to have 4 distinguished panelists, all with considerable experience sitting as arbitrators in international arbitration for many years. Our panel includes both civil law and common law trained and experienced arbitrators. In alphabetical order, we start with Domitille Bizot, who is a partner with Lalive, based in Geneva. She originally trained, qualified, and practiced as a litigator in New Zealand, but has been practicing exclusively commercial and investor state arbitration for the last 20 years, based in European civil law jurisdictions, acting both as counsel and as arbitrator. And she holds positions in several arbitral institutions, including on the ICC Court of Arbitration. Second, we have John Fellis, who is an independent arbitrator with over 3 decades of experience in international dispute resolution. Third, we have Professor Doug Jones, AO. He is an independent international commercial and investor state arbitrator and an international judge on the Singapore International Commercial Court. And fourth, we have Karl Malenvaux. She's the head of International Arbitration Practice Group at GID in Paris, with a dual background in both civil and common law. And she splits her time acting as arbitrator and counsel in both international commercial and investment cases. Alexander, do you want to say some opening remarks about our panel before we begin?
Yeah, thank you. As you all may expect and potentially know, I'm a numbers person. So I did some quick math, and this panel joins more than 75 years of experience. And I understand it's been involved as arbitrators sitting or presiding over more than 300 cases. So I think it's fair to say we have a wealth of experience. And I, for one, am very curious to learn about the do's and don'ts. And maybe not learn it the hard way in the hearing, but hear it from you today and avoid it in the next hearing. John, do you want to talk quickly about how we organize the session?
Yes. So we there are a lot of issues to address. We won't get to all of them, but we thought perhaps the easiest way to organize the discussion, and it will be a little roundtable to hear from the experience of our panel, is to walk through an arbitration roughly along chronological lines, starting at the outset with procedural conferences, case management conferences, and to walk through the issues. Obviously, many of these issues overlap various stages of the arbitration, so we can't stick religiously to that organization, but it is a framing mechanism that we will use throughout. And Doug Jones has helpfully prepared a PowerPoint presentation that addresses his views on many of these issues. I believe that PowerPoint will be available through GAR, but we will have Doug turn to particular slides in his PowerPoint from time to time to address certain issues. And so with that, I think before diving into the issues raised at the outset, I wanted to get our panelists' thoughts on the proper roles of the participants, focusing primarily on experts and also on counsel. What is it? What is the proper role for experts to play on damages issues? What role should counsel play in engaging with the experts and presenting that evidence to the tribunal? And I think I'd ask Doug if you could start, and perhaps we can pull up your slide presentation and look at slide 3 and 4 on that. So Erica, can you share the screen with Doug's PowerPoint presentation? Thank you. So Doug, if you want to take over and share your views on the role of experts.
Thanks very much, John. Party-appointed experts are a particular common law concept. Of course, domestically in civil law jurisdictions, tribunal experts tend to dominate as part of domestic processes. But party-appointed experts in a whole range of areas in international arbitration are more generally used than tribunal experts nowadays. I think the role of the expert is more or less settled now. And if we could move to the next slide, please. The role is generally accepted as one where there is a dichotomy between the position of the expert as paid for and appointed by a party and their responsibility to provide opinions to the tribunal and to assist the tribunal in the complex issues with which damages experts deal as an independent assistant, if you will, for the tribunal. Now, that's a bit of a schizophrenic role, and one with which we all struggle, I think, and have done in the common law field with experts in a whole range of areas for many, many years. It's been a relatively new problem for those from the civil law jurisdiction, but common law courts have had real difficulty over the years dealing with the party-appointed expert issues of bias and the like. We've now got the IBA Rules of Taking Evidence of 2010, which set out an independent role required to be performed by the expert, although appointed by a party. We have the Chartered Institute of Arbitrators Protocol of 2007, which establishes a range of mechanisms whereby the independence of the party-appointed expert is sought to be maintained. And of course, experts themselves bring their own professional codes of ethics, such as accounting and the like, to their role of experts. Thank you, John.
So, Domiti, I wonder if you could chime in and comment a bit on the structure that Doug just offered about the role of experts, and also share your views on that, and perhaps on how counsel fit in. I don't think we are hearing you. You might be on mute.
Now you can. I'm sorry. I was just thanking you for inviting me. I look forward to also hearing from our audience on a lot of these issues that are very important. I can't disagree with what Doug has said, but perhaps I'll take a slightly different angle, or at least in some aspects. I mean, damages experts, because that's what we're talking about here, are definitely here on the case to help the tribunal decide. But they also play an important role in helping the parties frame their case on damages. And I think that's perhaps the schizophrenic part of the role Doug was referring to. And clearly, on both counts, they need to be able to say it the way it is, and not the way counsel or the party want them to say it, i.e. to be truthful about what can be claimed, what can't be claimed, and why. But I often hear this framed in terms of duty, their duty to the tribunal. And absent this clear overarching duty, they're effectively acting as hired guns. I don't think it's quite that way. An expert working with a party is not necessarily a hired gun, because the expert is actually part of the team and part of the counsel team. So to my mind, the expert has, at least to quite a significant degree, the same duty, or at least the same strong interest as counsel, not to mislead the tribunal, because this will affect his or her credibility in the case. And frankly, his or her reputation as well beyond the case. So I've always been a little bit not skeptic, that's possibly too strong a word, about the need to adopt protocols like the Chartered Institute protocol in every case, as if this was the absolute solution to what, frankly, is a mess created by common law lawyers in the first place. There are cases that are not necessarily, don't necessarily require this. And in the world of international arbitration, there are still people who think a bit differently, who take slightly different approaches. And we have to be mindful of that. What I mean by that is, as an arbitrator, you sometimes have reluctance from counsel and parties in adopting the kind of protocol Doug just referred to. But we as arbitrators should not immediately conclude that this means the experts are going to behave like hired guns, because that may not be the case. So being mindful of different approaches rather than impose yet more protocols and guidelines on experts and counsel would be my 2 cents worth on this topic.
Carol, maybe you could add to that on the intertwined nature of the legal and the quantum issues.
Yes, thank you, John. Well, thank you to everyone to come for this conference, and I also look forward to some fruitful exchange with the audience. Before stepping in, I must say that I completely share Domiti's point of view on the two schizophrenic approach, credibility, and also the fact that international arbitration has its own momentum that is not to be compared to what happens eventually in court litigation, including common law court litigation. But stepping back to the point you mentioned, Jonah, and maybe at the risk of stating the obvious, I think we have to go back to the role of arbitrators also. I mean, at the first stage, we are no one. We don't know the case. We're chosen by the parties. We have no knowledge of anything. And we are entrusted with the greatest responsibility and power to finally decide a case with proper motivation and get an award that is enforced. And for me, it is the dynamic of the learning curve that is really interesting to explore when we're talking about damages issues, and to sort of break this fundamental imbalance that arbitrators, unlike parties, do not have access or direct access to evidence, do not have direct access to experts, do not have direct access to parties. That's the first major imbalance. And the second major imbalance that I think has to be in the back of the mind, even when we talk about damages, is that we are only 1 or 3 persons compared to an army of people who is working full-time on a case with partners, associates, trainees, and sort of mastering and working on all this evidence. But we are solo, and we have to digest all this, and we have to understand all this, because we are, at the end of the day, the ones that are going to be deciding. So coming back to experts and counsel for damages, here is where I think there's some peculiarities, because a lot of these issues are intertwined when we talk about damages. We cannot talk about damages without knowing what is a recoverable damage, i.e., in basic things like certain, direct, foreseeable. If the counsel does not properly somehow educate, but somehow exchange extensively with experts, so that the experts grasp that the kind of evidence he or she has to bring to the tribunal is something that is going to be useful because it fits actually the legal criteria, then there we are missing the goal. It's a teamwork for me between counsel and experts. And it's also after a teamwork towards the tribunal, because all these exchanges, we have all been counsel, all the exchanges that the counsel are having with the experts, the challenge they are having, the explanation they are seeking from the experts, so that after all it gets digested, has to be somehow brought to the benefit of the tribunal also. And that's where there's the second translation from the experts to the tribunal. And I think this teamwork of counsel experts for the benefit of the tribunal is something that mustn't be underestimated, especially because most of the arbitrators have essentially a legal background, although they're becoming more and more familiar with economics and numbers. We still, most of the time, are lawyers. And second, we are just single cowboy in the middle of a major scene where a lot of people are working 100% of their time to somehow bring to maturity some concepts that they master at some point better than us, but we have to get that knowledge. I think that was mainly what I wanted to share with you here.
So we have a question. I don't know whether any of our panelists are familiar with the decision of Lord Justice Coulson in the recent Court of Appeals case, Secretariat versus A Company, that dealt with potential conflicts between the expert's duty to the client and to the tribunal. But if anyone does have views on that, please feel free to share. In the meantime, I wanted to ask John for your views on some of the challenges that this places on the arbitration and on the arbitrators, and then maybe start shifting into solutions and what you think should be done at the outset of an arbitration to address some of these issues that the other panelists.
And I too will begin by thanking you for the invitation to be here today. In terms of, and I also agree with everything all my distinguished co-panelists have said. In terms of the duty of the expert, I think we all need to face one reality, and that is I have never seen an expert come up with a less favorable damages opinion for the party that appointed her than that offered by the opposing expert. I've just never seen it happen. Now, it doesn't suggest in any way that there's anything nefarious involved in that. I think there is a duty to the tribunal. At the same time, a particular expert will bring to bear her or his judgment on behalf of the party that engaged her or him, bring to bear his or her judgment and expertise. I think one important issue when it comes to the interplay between counsel and experts is this issue of assumptions. We see it time and time again, where an expert's opinion is based on assumptions given to her or him by counsel, and sometimes there's really no arguing with the assumption. And I will speak about New York law, for example. But if you have a case assessing whether a liquidated damages clause is an unenforceable penalty, the law is absolutely clear that the assessment is made at the time of the contract. There is no dispute about that, and there's no quarrel with an expert who takes that assumption. That is the law. But there are other times that experts are given assumptions where the law isn't quite so clear. And then I think it's important for experts to be able to offer some rationale, if possible, for why they adopted the assumption. I don't think it's enough for an expert to say, well, I was just asked to assume that by counsel. I think if there's some plausible explanation from the standpoint of economic analysis that can explain the assumption adopted by the expert should give it. I had this come up in a case a few years ago where there was a big debate in the case as to whether the damages should be assessed at the time of the wrongful act or later. You know, it's the typical ex ante, ex post debate. And the expert actually gave a very simple explanation as to why he, in this particular case, assessed it at the time of the wrongful act. And he gave an example of which I understand, at least among economists, to be a famous example, involving a yearbook, Janis Joplin's yearbook. And for those of you too young to know who Janis Joplin is, let's just assume it's Stephanie Germatoa's yearbook, who is better known as Lady Gaga. And suppose you went to high school with Stephanie Germatoa. She signed the yearbook before she was famous. Then I destroyed it before she was famous. You sued me for the $10 it cost you. And by the time it got to court and the court was about to resolve the dispute, she was Lady Gaga and the yearbook was worth a great deal more money. He gave that example as to say, well, look, this was obviously a windfall. That's why we should assess damages at the time of the wrongful act. For reasons I won't get into now, the tribunal rejected that, but at least it was an explanation that made sense. And let me stop there. I feel I didn't quite get to your second question, John, but I'll let someone else speak.
Well, perhaps
I'm not sure that Court of Appeal decision in England really touches strongly on the issue we're discussing. The issue there was Secretariat tried to be on two sides, both sides of the fence, in a particular project dispute. And the English courts said that wasn't on, largely based on the terms of the agreements entered into between Secretariat and the respective competing clients. And the real issue is whether, so far as Secretariat's obligation to their client was concerned, it was a fiduciary obligation. Court of Appeal overturned the first instance decision, saying that they were not going to go into the fiduciary space. They relied on the terms of the agreement. But in passing in that decision, there is clear assumption that experts are required to assist the tribunal in what they provide by way of evidence. But it's an interesting challenge to the business model of these massive firms of experts who try to become all things to all people. So I think that was the concern that for the future it represents. My experience is different to John's, so far as experts expressing views that might be contrary to those of the party that appointed them. The high water mark in my experience of this involved the calculation of damages arising from alleged disruption on a 4-unit nuclear power plant in the Middle East, where there were a whole range of experts on a whole range of issues, but the issue of disruption damages was the critical question that 2 experts had to deal with. Following a process of proactive management of the experts by the tribunal, the 2 experts on this area of damages agreed both on the method of quantification and on the quantification itself, and at the hearing made a joint presentation which left both parties squirming, but which, after being invited, neither party in fact challenged, and which of course the tribunal accepted. And for me, that was the most effective way I have yet seen of experts actually working together in the interests of their clients and of the tribunal to achieve an outcome which was consistent with their professional expertise and ability.
Mathieu, I wonder if you could, we could turn to some of the issues that are raised at the outset of an arbitration and what approaches you believe help to structure the damages issues to manage them throughout the course of the arbitration.
Yes, I think this is a very important point. What can tribunals do at the outset of the proceedings? And to me, the primary, the most important approach is to really explain the goal here, remind the parties of the goal. The goal is to help the tribunal. And more specifically, the goal is to avoid ending up with expert reports like ship passing in the night. The tribunal needs responsive reports and clear ideas of what's agreed, what's not agreed, and what is it that the tribunal will have to focus on. Now, there are different ways you can achieve that. Doug mentioned some of them, and there are others that I have seen done successfully or not. One of them is to ask parties to identify quite early the areas of expertise that will be required if they're prepared to disclose that. And this avoids, for example, having only one side deciding to appoint an expert on damages quantification and not the other. But there are issues with that first approach. You can be in a situation where the case at the outset is not sufficiently developed for both parties to say whether or not they're going to require damages expert. It could also be that one party says there's absolutely no need to even enter into a discussion on quantum. And I think it's hard for the tribunal at that point to force down the issue. Then there are other things you can raise, like the option of expert meeting after the first round of brief and get to a joint memorandum. And I purposely say an option. I know it's very close to Doug's heart, for example, to proceed in that way and is part of his active case management techniques. But I'd like to make a couple of remarks on this approach. It is a difficult exercise to impose on parties before they have sufficiently developed their case. And I personally find it useful to have expert reports with the first round of submissions, perhaps because I tend to view more the expert also part of the team, helping the team develop the case. The second issue I've seen in practice is counsel and experts not wanting to do this because they say it's effectively preparing a third report. This joint report was areas of agreement, disagreement, there are cost implications. And let's not forget the cases we hear about on GAR are all very high value, complex cases, but there are lots of cases for which this may not be appropriate. And true, counsel sometimes simply don't want to relinquish control, and that's why they don't want to do it. Whether the tribunal could impose it, I'm not a fan. Certainly at the outset, I think at the outset it is difficult to say you are going to have a joint memorandum, you are going to meet, etc. But equally, I do get very annoyed when you can't even raise that option. You can't even say, look, second case management conference after first round of submission, let's press the pause button and see what we should do now. Should we have a joint report? Should you meet before you move to your second report to ensure it's really responsive? And the reluctance, I have to say, is not always from counsel. It also comes from arbitrators. But in my view, that's a very important tool. And that requires tribunals to be engaged at that second case management conference and not only just before the hearing.
Karl or others, do you want to share your views on some issues that can be addressed from the outset to manage the course of the damages issues?
Yes, thank you. Here we are only focusing on expert and damages. So I must say that at the very beginning, at the outset, it's sometimes too early to really give some precise guidance of any sort to the parties when we're talking about damages. What we can do, at least, is to give some kind of guidance of what we may need as a tribunal. Something like, well, we want to be clear that if there is an expert report, that the assumptions are going to be clearly set out, the sources are going to be clearly added. I mean, that's obvious for any good expert, but there are all range of experts, and some of them are less familiar with the exercise. Communicate all the sources so that we limit all the troubles that may occur if, for example, there are some sources that are not annexed to the expert opinion, and that's another incident for the tribunal. Envisage a joint report, but just flag the issue, not more than this. I think just general guidance is enough at the beginning, unless we are faced with a major case that has been running forever, where we already know that there are damages experts both ways, and that the ball has started rolling for quite a while. As far as maybe the joint report that was raised by Domiti, I think there's, of course, not one solution for all cases, but we must pay attention also to eventually the equilibrium between experts. I mean, all experts are not necessarily of the same caliber or the same experience. It only works if they are as skilled one in the other. I have seen, as any of us, joint expert reports that are just not useful for the tribunal, because obviously one of the experts is not playing with the same tool as the other expert, and at the end of the day just complicates the work of the tribunal.
So before we turn to the submissions and presentation in a little bit more detail, Doug or John, do you have further thoughts on steps to be taken at the outset?
Yes, I think that I find myself in fundamental disagreement with Domiti. The problem of experts providing their reports with the first memorial of each party puts them in a position of, as Domiti says, clearly identifying as part of the team for the particular party. And psychologically, that emphasis remains with them throughout the arbitration. They, whether you like it or not, are effectively the advocate for the damages position of the party. And clearly, each party has a case theory, and they must be entitled to present that case theory with calculations consistent with that case theory and consistent with methods of assessment of damages which relate to that case theory. But having them already in the camp of the party who puts their report in their first memorial means that at the end of the day, by and large, in my experience, the tribunal chooses, when it gets to the award, one expert or the other. And that constitutes an enormous waste of expertise, because there will be a range of very interesting views which each expert will have from their experience, which they could actually contribute to the tribunal's thinking about questions of not just assumption, as John mentions, but also methods of calculation. So the tribunal can have the benefit of both of the experts' expertise rather than having to choose one or the other, and effectively often waste all of the work of the expert who isn't accepted. although one sees in expert CVs, particularly from North America, CVs which declare that the experts have won a series of cases in which they've been deployed for their client. And that just illustrates for me the potential waste of truly valuable expertise. And if you're talking about cost, as Dominic was, there is no better way to waste costs in arbitration than to deploy experts and waste their expertise, because many experts command higher hourly rates than lawyers.
John, you've got to give me a short right of reply.
Absolutely. Absolutely.
And I actually don't think we disagree that much. I don't disagree with what you've said, Doug. I disagree about the timing. And I think this may come down to how you view the role of the expert. Beyond the schizophrenia we talked about at the beginning, there is a role to be played in helping a party develop the right case. That can be done with the right level of independence and honesty in doing this. There is that role, and then there is the role of helping the tribunal. What I find very disturbing is tribunal imposing at the outset experts working together before they even have themselves a clear idea of what the case is about. I was on a GAR event, the GAR Interactive Women in Arbitration, a couple of days ago. We had experts on one of our panels who said, you know, it's all very well, these tribunals who tell us, go and work together and agree. But when we ask to do this too early, it just doesn't work. And because we don't know what we're supposed to agree and disagree on. So I think we actually agreed, Doug, except perhaps on the timing of when this should be done. It doesn't need to all go to waste. I am in favor of tribunals insisting on joint work, but it's a question of when.
I don't disagree with that. And it's a question of proactive case management. And it should never be for the tribunal to impose on parties something that they're uncomfortable with. The processes that I've found that work effectively in this space are processes reached by agreement after discussion with counsel and the party.
John, any last words on structuring the damages issues at the outset before Alexander turns to presenting damages to the tribunal?
Sure, and I can't resist picking up on something that Domitil said, which is I have certainly had the experience as counsel in having experts come up with something that I had never thought of. And it would be damages that my client would be entitled to. It's not, some made-up manufactured theory of damages. And so I do think it's very important that there is free reign at the beginning, which I don't think Doug is suggesting otherwise. I think there is one benefit to Doug's approach, actually, is I think it does impose a discipline on experts to know that they're going to have to sit down with the opposing experts sooner rather than later. I mean, cross-examination, the knowledge of cross-examination, and I'm sure Alexander will know this better than anyone, it imposes a discipline on an expert. But I think also the knowledge that they're going to have to sit down with their opposing expert and discuss their report and discuss their views, I think is a discipline in the first instance. In terms of, the issue at the outset, I think one issue we haven't touched on is that of bifurcation. There's a lot to be said about that, but there's a lot to be said about it that we all know about it, which is obviously there are costs and benefits involved in bifurcating a case. And I think to some degree, the party autonomy should drive the process here. I tend to find and it's hard to generalize here, but I think often both parties are reluctant to bifurcate, although sometimes some are and some aren't. And then you have to engage in a cost-benefit analysis. But I'll just, stop there and let others weigh in.
I wonder where we can pick up those thoughts, John, as we turn to the next sort of larger topic on how to present these issues. And many of these same topics will come up in that context. So Alexander, do you want to turn to the next stage, so to say?
Sure. Talking about submissions, and by that I obviously mean the lengthy expert opinions attached with many appendices doing calculations, potentially live models and exhibits on literature and other models and cases. The question obviously that comes to mind is first picking on Domitier and Karl, who spoke about the interaction between counsel and experts. How do you see that communicating these damages theories and results to the tribunal? Is there an interaction between the submission and the damages report? And how, in your experience, would you prefer the damages to be structured for you to be the easiest digestible? Is it a brief opinion? Is it a very lengthy opinion? Is it a model that you can play with? Any observations that you think have worked extremely well?
I've spoken quite a lot. I'm happy for Karl to go first, and I'll pick up later.
Thank you, Domitier. Well, I think that there are two issues. The format first, whether it's from counsel or from experts. Basically, what I think works for counsel is this sort of translation, eventually, to reduce the gap from the technical aspects of the demonstration made by the experts and the digestibility, if I may say, for the tribunal. And so I appreciate when counsel somehow includes in their written submission, in a nutshell, short, focus, and simple outcome of the expert's opinion. They do not need to go too far on this, but sufficiently that it gives the architecture. But for the expert's report, whether it's the first or the second one, of course, there is a tension between the expert as to whether they are somehow trying to combat or to fight or to discuss with the other experts, or whether they're addressing the tribunal. And I think they must do both in a way. They must address sufficiently the issues that are raised by the other experts so that there is some clarity that emerges from that. But they must not forget the tribunal in their own discussion. It's clear that if an expert report is sufficiently clear and credible, with, of course, an executive summary, that will enhance the capability of arbitrators to understand and maybe to bring them to get into more details. If the report is structured so that you have in the annexes all the information you need, if you want to get a better sense of some of the issues that you haven't understood, then that works. What I would nevertheless expect is that the expert is actually focusing on core matters, addressing the other experts' issues and not avoiding it, and clearly putting forward his assumptions. And here I'm only focusing on the format, and maybe, Domitier, you wanted to pick up also on the substance, because I think we have a little bit of the same view on this, but I would rather leave you getting there.
Thank you, Karl. On perhaps something obvious, but sometimes forgotten, including by good experts. I saw on the chat someone say the speakers obviously have been choosing the wrong experts. But actually, you have some very good experts who forget that you have to keep things simple. And it's better to make things too simple than too complicated. And the use of annex is great for that, because you can include basic definitions, and then you know that it's covered for the tribunal. I said that during our preparation meeting, and there was some eyebrows raising when I said it. Arbitrators are not our lawyers, Lawyers are not good with figures. They're not like you, Alexander. And even when they have very good judgment, they may not be so good with figures, but they're actually even worse at acknowledging that they're not necessarily good with figures. And they only do that in the deliberations when it's too late. So I actually think there's a lot to be said for education of arbitrators through the expert report. Now, on substance, I just want to make one point, which is perhaps also a little bit controversial with some people, and that's the importance of a commercially reasonable decision or outcome to a case. And that may make some of the common law lawyers here cringe a little bit. But I think the way arbitrators think, it is fundamentally important, and it applies to quantum as well. And let me perhaps give you an example, because I've seen that so often in deliberations. You have a great DCF analysis that produces a result of, say, 500 million in damages, and you have some other bits and pieces on the file where you have a tribunal member who's just going to go and pick up some other figures, maybe the last available EBITDA, and he or she is going to think, okay, if I multiply that in my head by, say, 10, 11, or maybe I go up to 12, I get to a figure that's around 50, 70 million. And he or she will start thinking, okay, how do I reconcile the two? So what I'm trying to say is we should not underestimate, and certainly experts should not underestimate, that there is a little bit of reverse engineering going on when tribunals discuss damages. I'm absolutely convinced it's not the case if you have Doug as your president. But I have seen it, including with eminent arbitrators. And then we get into all sorts of issues at a later stage. And maybe we'll come back to that when we come to post-hearing issues and what sometimes go wrong. But if enough is addressed upfront in the expert report, you avoid that kind of problem.
And do I understand you correct? And maybe John and Doug can chip in with their opinion on that. That the expert providing to use some of those comparisons help you rationalize about the damages and its relationship actually to the claim and to other figures that are eminent in the proceedings. Would that be of benefit to the tribunal in your opinion and observation?
I was just going to pick up on something that Domitil said about this reverse engineering notion. It was dramatically illustrated in a recent case in the English High Court called, sounds like it's out of Harry Potter, Doggermore Trade versus Caldor Consulting and Anor. Anyway, in that case, there was an agreement to a joint model for damages. Parties agreed, the arbitrators purported to apply it. But instead of subtracting tax liabilities, they added tax liabilities. And instead of awarding what should have been $4 million, they awarded $58 million. And the losing party, Doggermore, went to the arbitrators and said, essentially, can you please correct this? You've made an error. Can you please correct this? London ceded under the LCIA rules. And I know who the arbitrators were, and certainly Doug wasn't one of them. In fact, no one here was one of them. The arbitrators declined to correct. They said, yes, we've made a mistake. But they said this 58 million felt about right. They didn't use the word feel. What they said was that they took, quote, a more holistic and more subjective evaluative exercise, which sounds like something your yoga instructor may say to you. In any event, they stood on the number, even though they offered no reasoning, even though it actually defied the model. Of course, Doggermore then went to the English High Court and sought to set it aside on grounds of irregularity, serious procedural irregularity under Section 68 of the English Arbitration Act. And the court, rather than set it aside fully, sent the case back to the arbitrators. But I think it's illustrative of the point that arbitrators often do work on a sense of feel. And so to some degree, that has to guide how people present cases. If there is something dramatically outlandish in an opinion you give, outlandish relative to, say, a historical record of sales, then I think you're just going to lose the arbitrators. Because it won't feel right to them. And you know, the acknowledgement of that, of course, is it's not every arbitrator is like that. And I think, you know, a lot, and I think everyone on this panel is very rigorous in their approach to things, but it is a fundamental reality.
Well, I think that this issue of reverse engineering arises sometimes because it's not clear from the expert reports what their real differences are. They will have differences of assumption that they've been asked to make. They'll have differences of data that they often use asymmetrically. In other words, they're relying on different data sets. And they will have different views about the appropriate way in which, from a professional perspective, damages should be approached. And I think for tribunals who do an honest job, rather than provide a seat-of-the-pants outcome, or worse still, a negotiated outcome within the tribunal, having the opportunity to make judgments iteratively about which assumptions should be appropriate, which methods of calculation appear from the expert evidence to be those that should be adopted, and which data should be applied by the experts in reaching a conclusion is critical to an objective outcome to which parties are entitled from a tribunal, rather than some gut feeling of what they thought should be the figure. And that's why I am so keen on engagement between the experts, so that tribunals have a view from both experts in relation to these potentially differing areas upon which their opinions ultimately are formed.
In following up on your explanations, am I assuming correctly that a live model, so a model that actually does the calculation, which identifies the key assumptions and is actually something that you can then adjust? And let me chip in, if it's still too complicated, as some models will likely be, potentially with the help of a tribunal-appointed expert, just to make sure that the use of the model is correct. Is that an alternative, an approach that you see in practice, or is that something?
I think you. I don't know if I'm on mute. I don't know if you can hear me. I seem to be frozen.
Yes.
I think we may have lost Domiti. I wonder if others have follow up on that issue. I mean, how best to approach that? When to raise those issues that Doug addressed? Getting experts on the same page about assumptions, pre-hearing, how to do so, what steps can be taken at the hearing to address these issues.
Yeah, just to pick up first on what on the previous discussion, I think reacting on what hopefully Domiti was going to say, but I see she's back. She may add to this. You were proposing, Alexander. We give you the methods, we give you the Excel sheet, we give you the key assumptions, so that you can eventually have the model. I think one thing is that it's not because you have a model and it's not because you have a calculation that you have a damage. And this is two things. And I think that was one of the, at least the idea that I had listening to Domiti. It's go back also to commercially sound assessment. Calculation doesn't make a damage, even if the figure is right, even if the model is right, even if everything is right. And it's here where there is a tension when suddenly you realize, well, they are asking 150 million on this, but I mean, all over the place, it's worth 10 million. What is happening here? And that somehow breach the trust that the tribunal may have and get lost. And of course, that's where Doug's addition on having the expert working one with the other and trying to discuss the key differences will help the tribunal. But still, if both experts are playing with key assumptions and figures, but the calculation once again ends up being right, but it doesn't mean necessarily that there is a damage underlying the calculation. And here it's sometimes difficult for a tribunal, because we do not want certainly to go back to gut feeling and just what we think about something. No, we want to address the issue properly. That's the basic that the parties have the right to expect from us. But maybe, Domiti, that was not at all what you were pointing at when you were cut off by the micro.
Apologies for that. First time it's happened. Luckily, it's never happened in a hearing, in a remote hearing. No, I was going to say, Alexander, the point you raised is really one that arises at the post-hearing stage. I think that one of the topic was, why do things sometimes go wrong? And I think that's where things go wrong. And of course, they go wrong because of all the things Doug have said. There's insufficient work being done before on what's agreed and what's not agreed, and a great deal of confusion. But to answer your point is, I find that slightly problematic that you get to the end of the case, and in fact, you would require to have another expert to work with the tribunals when the parties really spent all that money and time on their own expert. But the reality of these models that tribunals do sometimes get, and I have used them before, very confidently thinking if I just change the discount rate or maybe CapEx with what I've asked and what I've been given, I can make it work. And then I've sometimes felt, having an assistant to even do the number crunching on the basis of these Excel sheets would be better. And even better, it would be to have the opportunity to work with the experts at that point in time. And I know I'm jumping the timeline, John, I'm sorry, but since the question was asked, and I like the idea that I've heard Doug express to have experts working together. What is problematic, I find, is handing over the experts to the tribunal with the parties no longer involved. But that maybe we'll talk about later when we go back to post-hearing issues.
So we only have about 10
I've
minutes.
never had a case where the experts were unable to agree on a model. After encouragement, they've always done so. And to have a third expert intervene has never been necessary from my perspective. However, I think it is critical for a tribunal to carefully read the experts' reports, joint or otherwise, well before the hearing, and to engage in case management conferences with the experts well before the evidentiary hearing on where their differences lie, and to work with them and the parties on what can be done together with the experts to ensure that the tribunal knows exactly where the differences lie between the experts. The concept of throwing the experts into a hot tub at an evidentiary hearing without that level of preparation loses all the benefit of proactive case management, in my view.
Yeah, perhaps I'll just say one point on the hearing, John. I know you want to move to another topic. It's a simple point, but one that is too often forgotten by experts is there's huge value in being the one seen as trustworthy and reasonable and prepared to concede points. It's an incredibly good way to build the trust of the tribunal. And certainly in a pure adversarial system, that is very, very effective, to not be seen as the hired gun, as we said earlier, and be prepared to give alternative views and even provide alternative calculations, even if there haven't been calculations the party has asked you to perform.
So we have 10 minutes left and a lot of other stages of the arbitration to discuss. I would like to come back, Domiti, to the point you raised about how can experts assist after the hearing. But before we do, maybe briefly, John and Karl, if you have thoughts about how to bring experts together either prior to the hearing or during the hearing. Doug mentioned hot tubbing and what steps need to be taken prior to that to make it effective. I'd appreciate hearing your views.
And there's a question from the audience as well, to what extent you have used hot tubbing and if you think it's beneficial.
Karl, do you want to go first?
I liked your gentleman. No, well, just, the issue of having experts in pre-hearing, I would love to have this. How realistic it is, it really requires a lot of preparation. It requires not only that the tribunal is very much prepared, it requires that the sequence of the filing are such that counsel and experts are not like just 2 or 3 weeks before the hearing with the last filing. And in, at least in my experience, sometimes it happens that we do not have that much lapse of time so that we can really have, with sufficient knowledge, either from the tribunal or time from counsel, the time to have before the hearing a sort of a meeting with the experts that is fruitful. If that is the case, then I would really love to have it, but it's not always naturally possible. During the hearing, the hot tubbing, I think I completely agree with Doug. It's very beneficial if we know what are the issues that are going to be discussed, and it's not something that is just getting out of the blue at the last minute, because we do not want to have a fight between experts. We want to understand at the end of the day and to be able to make a decision depending on how those key issues were addressed by both experts. Maybe you want to step in, John?
Oh, only to say that I absolutely agree with you and Doug. Without an intensive amount of preparation, hot tubbing of experts, damages experts at a hearing it's to me a waste of time. It was in fashion when it first got into fashion. I was involved in tribunals when it was used a lot, and sometimes even decided at the last minute, oh, let's have the experts hot tub, and it really wasn't all that helpful. And I've only found it helpful when there's actually an enormous amount of work done by the tribunal members to understand the issues involved, and then it can sometimes be fruitful. But without that, no.
Doug, I wondered, since it's been raised, if we could go back to your slides, and Erica, if you could share the screen and turn to Doug's slide 9. Doug, you could share some of your thoughts on how arbitrators can work with experts after the hearing to assist with quantifying certain aspects of the damages.
Thanks, John. I agree with Domiti that lawyers are not necessarily mathematically astute. Some are, but some aren't. And when one comes to actually prepare an award, for the purpose of calculation, there is sometimes an opportunity, as has been mentioned, of having an agreed model where you can tick or deny particular assumptions, and as you build through the model, a figure drops out. However, the cost of models where there are a lot of variables can be very significant indeed. And if a tribunal has the opportunity, as it works through the assumptions that it needs to make about, or rulings that it needs to make about the real differences between the experts, having the experts available to do the calculations based on those conclusions is exceptionally useful. And I have found it works. I've not had a case where there has been either refusal by parties and experts to be involved in this process, or where there has been any untoward result. And what the parties get at the end of that process is an award with a separate advice by the tribunal of what the experts have done and how they've done it, so that the parties, if they disagree with the calculations the experts have done for the tribunal, have a chance to get them corrected, which sometimes occurs. And you can be sure from that process that you have a correctly calculated award. The prospect of some tribunals doing calculations, thinking, as Domity says, that they can tweak a particular assumption about capital or EBITDA or whatever, is a horrifying prospect, I think, for most experts, and certainly for parties. And this process I have found works well. It works particularly well in the context where there are publicly listed companies who do not wish, until they get the final award, to be making statements to the stock exchange about partial rulings by the tribunal which could impact the share price. And so you get one outcome, the parties understand how it's worked, and in the process in between, the experts work for the tribunal, and the tribunal certifies the fees they charge, which are paid by the parties in that process.
Can I comment briefly on that, John? Or
yes, I'd like to open it up to all of you to share your thoughts on some of the challenges or the prospects of the approach that Doug has out.
I think the approach insofar as it then clearly involves going back to the parties is a very good one, and one that is definitely favorable to not only tribunals playing with figures the way I was describing before, but another approach I've seen done and I find very frustrating, which is the tribunal actually going back to the parties with a series of questions, asking for new models, but dead scared of being seen as favoring one figure over the other, one approach over the other. So asking a whole range of different things to be recalculated so as to not give away what they're thinking and making sure they're not taking anyone by surprise and then making a decision. I've seen this done for fear of being seen as going too early in one direction. And I have to say, I prefer Doug's approach, which is to let's just take quantum, work with the expert. But Doug, I haven't seen it done. I've never seen tribunal suggesting that it be done, because again, I think tribunals don't like talking too much about how much they do need experts when it comes to damages calculation.
Well, I've done it in about 20 cases so far, and without difficulty and with considerable levels of ultimate assurance of accuracy.
So we're close to the end of our session. Karl, John, I wonder if you have any thoughts on this or other topics that points you wanted to raise.
Karl, do you want to go first, or I can?
Well, just one thing. I mean, tribunals need and like experts, and we, depending on the matters, but on damages, this is certainly true. But we need clarity and credibility. I mean, if that's the two things that really needs to be focused, clarity and credibility. I know it's a big word, but we do need help, but we won't get the help we need if it is either not clear enough or you have lots of credibility because you have made a calculation that is completely outrageous and then came back to something that is more reasonable, or you have refused to review some assumptions that were to be challenged. Things like this are extremely difficult to recover the trust of the tribunal. So it's a long process from the beginning to the end of the proceedings. But if as an expert, with the help of the counsel, you gain the credibility of the tribunal, then it becomes a real help for the tribunal.
And let me just, the only thing I will add is I absolutely agree with Doug's approach. I think often what happens is when arbitrators sit down at the end and start to write the award, and especially the award on damages, it's then that they realize, I'm not sure I fully understood this point. And the ability then to actually be able to bring in experts and have that assistance at that point, I think is essential.
Can I just add, though, that it's critical that the experts only be used for calculation. If the tribunal has a new theory or whatever that it wants submissions on, that should not be given to the experts without the parties having a chance to comment. This is a pure calculation exercise.
Alexander, do you want to wrap up with any comments on the panel?
Let me try to avoid the most common mistake in online conferences. Just very briefly, because I think we're already over time. Thank you so much for sharing your insights. I, for one, learned a few lessons. I'm hopeful to see more of what was discussed today being actually employed by tribunals, because very often I think experts actually would want some more guidance also from the tribunals in their schizophrenic role that you have been pointing and referring to. So thank you very much. I'm obviously looking forward to the discussion later on. I'm hopeful that some of the participants will pick some of those discussion points also for the question session later today. Thank you.
So I want to just thank all of our panelists for your insights and your preparation for today and sharing your thoughts. I'm glad to hear we have disagreements on some issues and agreements on others. And with that, we'll close the first panel.
Welcome to everyone. We have an absolutely fabulous panel. Having heard the views of the arbitrators, we have a lot to say in this panel because I'm not sure that the views of the users, the counsel, and the experts in terms of what they really want from arbitrators are all the same. And I think we'll have some comments on some of the proposals in terms of best practices. In any event, I'm Carolyn Lamb at White & Case and do both work as counsel, an advocate, and an arbitrator. I'll take just a few minutes to introduce quickly each of our panelists because you will see that we have someone from each perspective that you'll hear from. And then we will jump into the substance because we've got a great variety of views to share that I'm sure you'll find interesting. Ronnie Barnes co-heads Cornerstone's researches international arbitration and litigation practice, testifies regularly on all aspects of damages. He's the expert we want to hear from. Karl Hennessee is Senior Vice President for Investigations and Regulatory Affairs at Airbus. He's been at a variety of companies, but really he's the client and can contribute the client perspective. He's served as chairman of the governing board at the ICC Court of International Arbitration. He knows arbitration. He knows running major disputes. From the client's perspective, from the advocate's perspective, and you will see a blend of those things as you listen. Craig Miles is at King & Spalding in Houston and specializes in international arbitration, primarily on the claimant side, but all kinds of disputes, ICSID, ICC, AAA, and has really done some major disputes. So he can give us certainly the claimant's advocate perspective. And Dr. Anke Sessler is really widely renowned as one of Germany's outstanding disputes lawyer. She's been in-house at Siemens. She's at Skadden and has been there for several years, and a wonderful advocate on the ICA governing board, very well known. So you know where each of them is coming from. Let's jump right in. I think the last panel left us with much to think about, but I think we'll start so we can see where each person is coming from. What do you find frustrating about tribunals, arbitrators' treatment of damages issues? Let's start with Ronnie.
Thanks, Carolyn. Let me start by apologising for the fact that I missed the last session. So there's a danger that what I have to say has been somewhat preempted. But I think it's an interesting question as to what, as an expert, you're looking for from an arbitrator or from a tribunal. And I think it's important to sort of say that this is, what I'm about to say is predicated on the assumption that we've done certain things right in advance. So, for example, I think it is really important that the expert is fully engaged with the lawyers in making sure that whatever it is we're putting forward is completely consistent with the legal theory of harm, so that the damages expert is not out there on a limb doing something that's independent of what the legal team are doing. I think it's also really important that we have made a real effort to fully and clearly articulate what it is we're trying to say in as simple a way as we possibly can, while not oversimplifying it. So those are the preconditions, I think, for us being able to ask arbitrators and tribunals for certain things. But assuming that that's the case, I think, and this may sound overly sort of simplistic, I think what we're really looking for is for the tribunal to genuinely engage with what it is we have to say. I think sometimes there's a feeling that somehow damages, valuation, quantum, whatever heading you want to put it under, is so specialised and so esoteric that it's just impossible for a tribunal member to get their head around. And having taught for many years in a business school and taught people the basics of finance, I actually just don't think that I don't think that what it is we do is actually that difficult. I think, as I said, if we've taken the effort to really sort of explain it clearly, I think looking for the tribunal to really think about what it is we have to say and frankly do some homework. I mean, I think, as an expert, we will put together a report that makes an argument, and we put in sort of sites that support that argument, and we know that the opposing expert will do the same to put together a competing argument. I think it would be great if the tribunal said, okay, well, you're citing to, getting slightly technical for a second, we're arguing about whether or not to include a specific risk premium in a discount rate. Don't just read the expert reports and try and understand it from there. Go and look at what's being cited, really understand it, because there are some key issues here I think.
Great. I think we got the expert view. I'm just asking for a capsule, really, of what you find frustrating. And I've got a whole series of additional follow-ups. Karl, do you, as a client, find in the arbitrations that you've been involved in what the tribunals have done frustrating, or are you pretty satisfied? What do you think?
So first and foremost, thank you very much to the organizers for having invited me to share my point of view. And on the whole, I am more frustrated than I am satisfied. I echo some of what Ronnie said, but much more of what the tribunals themselves acknowledged in the previous panel. In other words, I heard again and again statements like lawyers are not numerate, lawyers are not number specialists. And Ronnie's put it a slightly different way. But to be honest, one of the things that I find is even very well-prepared tribunals on the merits will go silent as a school of mackerel the moment the damages issues come up, inevitably at the end, even if it is the tail wagging the dog. And it's extraordinary to me how essentially most members of tribunals are able to give themselves a pass, even though I think that most of the time, experts on both sides put a great deal of effort into simplifying, perhaps even oversimplifying some damages points. And I find not always, but occasionally, and this is the temptation that I really would put some critique on, there is indeed a preference with going with the simpler explanation, not in Occam's razor style, but even to the exclusion of evidence that it doesn't work. And one of the wonderful examples I would cite is a tribunal that I was involved with many years ago. They were really on top of the liability issues, but the damages issue was effectively, were delayed purchase orders denied to us as the claimant, or were they merely delayed and therefore was interest due? The basic background was that the respondent was on the brink of bankruptcy, and therefore it was obvious that delayed equaled denied. But the theory was so simple and tempting that they just went with it. And the explanation in the award was basically 3 paragraphs long. And guess what? The award was rendered 2 weeks after the respondent went bankrupt.
Craig, in your experience, do you find it better if you really serve it up in a focused, concise way to get a better result?
Well, first, thanks everyone for being here, and thanks to the organizers for the invitation. It's a great question, Carolyn. I could probably spend the whole panel talking about some of the frustrations that I've experienced as claimants counsel in terms of quantum. And I think picking up on what both Ronnie and Karl said and what the prior panel said, I can't tell you how many times I get the sense that the tribunal is focused on damages, not even as late as the start of the hearing, but really the night before the quantum experts have gone on. And I think better case management at the beginning and focus on quantum at the beginning is important. And everyone keeps saying it, but I rarely see it done. And just to give a simple example, others earlier today talked about the concept of the damages experts being, 2 ships passing in the night. And that is normally crystal clear by the end of the first round of memorials. And more often than not, in my experience, the reason the experts are 2 ships passing the night is not because they have different views about the core economic issues or the core quantum issues, but because they're being given different instructions by the parties. In a case of, say, an oil field, the claimant says, assume that we're using current oil prices and using this production schedule and this tax doesn't apply and we get a 10-year extension. And the respondent's expert assumes 2009 oil prices, a different production schedule, no extension, and this tax applies. And they get to 2 vastly different numbers. And the tribunal, if they recognize at the beginning that these different assumptions are in play, can instruct the experts in the second round, well, what would your assessment be if you use these different assumptions? And more often than not, I think the case will be that the experts have more in agreement than they disagree. But instead, what happens is the tribunals don't focus on this until the hearing, or maybe in a post-hearing joint report, when all this could have been dealt with in a much cleaner and more efficient way if the tribunal would engage in these issues much earlier on in the process. So I think that's an important threshold problem that repeats and I think can be corrected. Before getting into more specific.
I'm getting to, but just to follow up 1 minute on that, don't you think one of the issues is, of course, that the tribunal hasn't really deliberated very much at that point, hasn't come to conclusions on liability, and therefore cannot really work through the damages issues until they've done step 1, because the causation link is so important. So I do think, and we'll have a question separately to follow up, I do think it really important for tribunals to manage the flow. What you want from arbitrators is to give the parties some feedback and allow some due process before you go off and decide damages on your own, and hear further from the experts and from the parties. Ank, do you have a comment?
Yeah, so I share the view here, obviously, of everyone. I think that the crux of the issue is really not so much that arbitrators don't like numbers. I think the real issue is really the case management techniques, and that arbitrators really do not start really from early on to structure the case, and to make sure that experts, at least at a certain stage of the arbitration, have the basis to produce views which are based on a common basis in terms of legal framework and also facts. And I have seen arbitration proceedings where both parties submitted extensive expert reports on damages and expected to receive a comprehensive arbitral award dealing with both liability and damages, but then the arbitral tribunal only issued a partial award on liability and provided the parties with certain instructions for further submissions on damages only then at this stage. And the experts then had to draft new reports, and all their prior work was in vain. So that is one example of my own practice. And then I think you also have the case that the tribunal does not engage at all with the damages. They focus on liability questions. So in a very recent case of mine, at the end of the evidentiary hearing, the tribunal, upon both parties' requests, provided the parties with a preliminary assessment of the case, which was intended to serve as a basis for settlement negotiations. But while the tribunal provided the parties with extensive explanations regarding liability, they completely neglected the damages aspects. And although respondent had argued in detail that most cost items, claim were either inflated, contradictory, inconclusive, or unsubstantiated, and this shallow treatment of the issues provided the parties with little common ground for settlement negotiations. And the result is that we are still involved in the settlement negotiations and have still not have a settlement.
So what is to be done is let's focus on before the arbitration. For clients and counsel, do you focus on arbitrators who may be skilled with accounting or damages analysis, or do you also involve the clients in the selection process for the damages expert, so that you're absolutely confident in what that expert can do and how they might interact with the arbitrators? I guess we'll start with the client perspective and then go to Ronnie, the expert perspective.
I mean, I think that a question raised in the chat by Domitil Bazou is actually right on point. We've talked about the role of the tribunal, but you're highlighting the role of the client, and I take my full responsibility for this. The first thing is, inherent in your question is the supposition that you hire the expert after you've hired counsel. I don't do it that way. I hire the expert at the same time as counsel, or if I think the damages issue is more important, I'll hire the expert before I hire the counsel and take into account the expert's opinion in which counsel or what qualities of counsel to look for. Second, I also am very interested in the voice of the expert in selection of arbitrator, because there are definitely exceptions to some of the critiques that we've been talking about, and some of them can be absolutely decisive, more decisive than seniority or even familiarity with the underlying law in some cases. The third thing is you have to have the courage and even the authority as a client to challenge the way things have always been done. If you always do what you always did, you'll always get what you always got. And in that sense, I am an enthusiast for radical ideas like reverse bifurcation. I am an enthusiast for basically forcing the other party at mediation to confront damages issues by choosing a mediator who's focused on that, as well as also making sure that our experts are participating, et cetera, things like that. And it isn't fair to basically just say the tribunal isn't reacting to the damages issue if the first time you as client, as counsel raise it is right before the hearing. And so therefore, we all have to take our responsibility on this. And mine starts with the simultaneous selection of experts from a pool of experts with which I'm familiar, not necessarily based on the recommendation of my counsel.
That's an excellent point and approach. Ronnie, what do you think as an expert?
So I must confess, I've never experienced what Karl has just described in terms of being brought in before counsel. I mean, that is certainly a novel idea. But I do think it sort of goes back to a point I made in at the beginning. I think there is sometimes a tendency for the damages experts to be brought in quite late on when a lot of the thinking has already been done. And it's not exactly a fait accompli, but it's a pretty well defined sort of piece of work that you're looking for. Whereas I think the earlier that you can get involved and be involved in the discussions about, the way that, as I said, the legal team are thinking about the case, it just it's going to lead to a more sort of integrated product, I think, and something that, to the extent that the tribunals see the lawyers here and then the experts here, I think thinking about how to sort of tackle that preemptively, I think just does make a whole lot of sense. As I said, the idea of being brought in at the very beginning is interesting, but maybe a little scary as well. But
So, Craig, what do you think? Do you look for arbitrators with a good damages background, or do you have clients participating in the selection of the experts?
So it's interesting. I haven't had a situation or a client like Karl's where the client has brought the damages expert in at the same time as me, although I certainly by now have a few clients who are familiar enough with the universe of really good quantum experts that they have some views on it. But typically the clients will ask us to advise them on who they think good quantum experts would be. And then, of course, they'll interview them and ultimately be part of the selection process. And we also bring them in as early as possible to help us understand the case and to fully understand what the scope of damages are that we have. I think some of the prior panel members suggested that was an appropriate and I think a very important role for the experts. In terms of the arbitrator selection, certainly quantum is an important element to that. In investor state cases, there's always, in most cases, very complicated issues, usually of jurisdiction and liability, and you have to really factor those in. But in a clean case where quantum is going to be the ultimate focus, where the liability is clear, or let's say there's an expropriation and all you're fighting about is liability, then plainly the views of the potential arbitrator on quantum issues are important, potentially decisive, I would say, in some cases, and that is, the predominant factor in the arbitrator selection.
Hank, what do you find?
Yeah. Of course, I look for arbitrators who have the right expertise for damages. But I think that would be a little bit too small for me. I think damages very often are related also to the industry expertise. And I find it even more important to select an arbitrator who has experience with the industry, because then it's, I think, also a lot easier for him really to understand the damages issues. I think that is very much related. And my personal experiences, and now commenting on Karl also, that I think obviously Karl is a very sophisticated client, but as a general rule, I agree. So experts, and I'm sure Ronnie likes to hear this, experts really should be involved very early on. I think not depending on whether you will submit immediately an expert report or rather wait, but experience shows there are many conflicts of interest. You need to find the expert, again, also who has the right focus industry-wise, and then you need to get him up to speed. And that is something which really needs to be done very early. And then it depends really on the case management of the arbitrators and also on technical questions when you really submit the first expert report.
Yeah, and it's interesting, if you heard the discussion or what the discussion was, there were some very firm views in terms of whether it undermines the credibility of the expert if you submit, in fact, the expert report with the first memorial. Is it too identified with the party? Or conversely, is it really helpful from the outset? So it would be, I think the case management point is of utmost importance for the tribunal to express to the parties the approach they prefer and hear what the parties have to say on it, so that there's some understanding and agreement. I do want to shift to during the arbitration. We heard a variety of comments in terms of during the arbitration, what is it that the damages experts and, of course, the counsel should be doing on the treatment of damages. And I think all sort of agreed with what Craig expressed, that, and you, Anka, as well, that often damages are left till the last segment and not enough attention paid. And sometimes in briefing, damages may be left to the associates at the end or something. And so therefore, we really do need to focus on synthesized, focused damages reports to make it, to facilitate things for the arbitrators. But what do you expect in the briefing segment? And then I'm going to go to joint reports. But let's start in, if anyone has any observations in terms of what you want more from the arbitrators during the process of the arbitration. Questions or some guidance for the parties.
Here, I think we've already talked a little bit about this, that it's an interactive process. You know, there needs to be a dialogue ongoing in appreciating what role damages are going to play. You know, I have an absolutely wonderful dispute that's materializing right now. Only a sick guy like me would call a dispute wonderful, but this one is really interesting in the sense that the facts are not good and the law is uncertain, but the damages are really where we can win this thing. And it's materializing right now. And one of the things that I want to do with the counsel that I have yet to appoint, and that I am discussing with the damages expert that I'm already talking to about this, is how are we going to get the tribunal to focus on damages first, second, and third before they even reach liability? And so therefore, that question is at the heart of the strategy, not just the tactics of this particular dispute. And it can be on any other. The second thing is that we always, I think we too often think that the way to gain credibility with the tribunal is through our advocates, through our lawyers. But I'll tell you a story that indicates how important the damages expert can be establishing party credibility. I was brought into a dispute a couple of years ago, a very large dispute where I had not managed the outset of that dispute. There was not a damages expert that was preparing to testify in that case. I brought one in, someone I had worked with for many, many years, and he had a very fundamental, even violent difference of strategic opinion with my counsel, and each side was lobbying me to adopt their point of view. I finally went with the point of view of the expert. Truth is, because he acknowledged the fundamental accuracy of the other side's approach to damages from a factual point of view, not from a legal or quantum point of view, we did lose the case itself. But we won something much, much more important, because what was really at stake here were some post-award proceedings that were going to take place. And I can see, like a red thread through that award, the acknowledgement of the honesty, of the guilelessness of his approach to that, which is traced back to his willingness to disagree with my counsel and to lobby me to adopt his position, and so that he could acknowledge the fundamental correctness of what the other side was saying there. I'm not saying that'll come up in every case, but it only comes up if you actually bring the damages expert into the strategic discussions, not just into the discussions tactically about how the model is going to be presented.
I do think that's essential. Craig, it looked like you had a comment on.
Well, I would just say, it's a really interesting, it's an important point. And, it's easy, I think, for all of us to criticize arbitrators for not focusing enough on quantum, but it is clearly on the parties and the counsel who are drafting the pleadings to make quantum front and center from the very beginning of the case. If you've trained in the United States and you take any advocacy about quantum, of course, that's geared more towards juries than arbitrators. But the focus is always from the very beginning of the case, from your opening statement, through your threading, through your fact witnesses, through your experts, to your closing, that the damages, the way the harmful acts of the respondent, have hurt the claimant, needs to be front and center in terms of persuading the tribunal from the very beginning of the case. And so as advocates, we cannot draft a 200-page memorial that talks about the facts and the law and liability, and then summarizes the quantum in a few pages, and then punts it over to the expert report that is maybe 200 pages long and filled with 8 appendices, and expect the tribunal to grasp that or have sympathy for that, those types of calculations. So it's really on the parties to make it a focus of their pleadings, so that the arbitrators have the tools to understand maybe earlier on in the process, what the key issues are in terms of quantum, how they can streamline the process if possible, without prejudging, obviously, liability, and focusing the parties on the second round and even before the hearing on the issues that are really important to the quantum decision. But it's on the parties ultimately to put the arbitrators in that position to have the tools to make those kind of efficient decisions.
Anka, do you have a comment on this?
Oh, yes. I agree with Craig that, of course, to some extent, if arbitrators do not have strong case management skills, it's really up to us as counsel to compensate for this. And that really raises the question, when do you submit an expert report? Also, just on your own assumptions, or do you also take into account the factual allegations and the legal allegations by the other party? I think these are really tricky questions, and but that makes sure that you submit an appropriate expert report, even when the arbitral tribunal does not give clear instructions. I think which is of course what we clearly prefer. I would also like to comment on what Karl has said, because I think you called it, Karl, reverse bifurcation. I think that sounds very interesting, and to me, and also with a former in-house background, also very unusual, because don't you think that this can be a very costly exercise? And is it your approach, not depending on whether you are in a claimant's or a defendant's position? Because as a defendant, would you really like to talk about numbers before you have really debated the liability?
The answer is absolutely yes. And this lesson can be learned not just from the example I gave, but from no less a personage than Donald Trump. Among Donald Trump's many failures was the attempt to start a competitive sports team to the National Football League in the United States. He called it the XFL. And at some point, his lawyers brought an antitrust claim against the NFL, which went along for years and years and years and years. And ultimately, he received a judgment in his favor. Indeed, it was found that there had been a conspiracy among the team owners of the National Football League teams to exclude and systematically try to destroy the XFL. However, the coda to that was damages were awarded in the amount of $1. And if the strategy of the National Football League had been instead of trying to fight the conspiracy claims, and I realize this is not an arbitral example, but I've seen it in the case that I described to you and a number of others, that was the main event. That was, where essentially the proper emphasis of defense could have and would have and should have been placed. So odd that, Donald Trump has that to teach us, but indeed that case is as good a public illustration as I can give, but I could give a number of others, but they involve confidential facts.
So Ronnie, you've heard what the clients say, what the advocates say. What do you think is most effective for the experts' involvement during the arbitration?
So I think one of the great things about arbitration is that there's a lot of fluidity in terms of how the proceedings can be organised, and I often sort of think that that's not taken full advantage of. So if the tribunal is fully engaging with the quantum questions at an early stage, I think there's the ability to design the proceedings in a way that gets them to a position where they feel as if they understand the points that are being made. So, for example, I've testified in an arbitration where we actually gave evidence through presentations, and the two experts divided the topics in the reports up into sort of sections. We presented, were cross-examined, and there was a constant sort of dialogue between the experts and the tribunal, which really gave the impression of the arbitrators really trying to understand where the differences of approach and opinion were between the experts. And I'm not saying that that's necessarily an approach that would work well in every sort of single case, but thinking early on about, what are the core sort of questions here that we really need to address from a quantum point of view, and what's the best way of getting to those questions, rather than just it being a formulaic way. I think that would, it's sort of a somewhat sort of bland recommendation, but I think operationalizing that in different cases, I think would advance things quite a lot.
Good. Well, we've seen in many cases, and we've heard some suggestions this morning about both hot tubbing and about joint reports. In your views, and I'm going to ask each one of you, so do they really justify the expense? Have you actually seen anything that helps coming out of such a process? Or is it just a very pricey exercise? I think, Karl, we'll start with you.
Joint reports, never. I find that joint reports simply are too often an excuse for the tribunal not to engage with the damages issues, and when suggested by counsel or endorsed by counsel, are an excuse for them to basically punt on those as well. So not a fan, never seen it work. Hot tubbing, I can say there's an opportunity for a quantum expert to perhaps score some points on an opponent occasionally. But it may make a tactical difference, but I've never seen it. I've never seen it successfully resolve key questions to a dispute. Damages experts are generally too well prepared. They know where the bodies are buried. They know where the traps lie, and they may knock a corner off the block here or there off each other. But in terms of fundamentally reorienting the case, no, not that either.
And what do you think, Craig? Have you seen it work? Is it worth the cost?
Well, first I want to add one coda to Karl's story about the football antitrust suit. Under U.S. antitrust law, damages are trebled, so they actually got $3 at the end. So I fully agree with Karl. I mean, I have not found either hot tubbing or joint reports before a hearing to be particularly useful. I think for hot tubbing to work, the arbitrators really have to be prepared ahead of time. They have to ask questions. They have to know what the differences are. They have to really probe the experts. And I've just not found that the arbitrators are prepared, to do that in the few cases where I've seen it tried. And the joint reports, again, I have not found those to be helpful. Usually the experts kind of hold their ground on 90% of the issues and don't really concede much. The one thing, I don't want to jump ahead if you're planning to address this separately, Carol, but one thing that has worked in my experience has been the joint model, the model where the experts kind of agree on what the inputs are, and then the arbitrators can select the buttons in terms of, assumption A, assumption B, assumption C. I've had that work in a couple of cases. The first time it was tried, I was frankly quite surprised the experts were able to agree and put together this model, and that also became the basis for the award. So that, I think, is a little bit different and could potentially work. But if that's going to be another topic, I hope I didn't preempt you.
And have you ever used hot tubbing in a virtual hearing?
I haven't yet.
No. Karl, it looks like you have.
I have. And interestingly, I mean, I've done it now, I guess, on the quantum side, but the first confrontation I had with it early in the COVID crisis was when an arbitrator dynamically, and to our total surprise, hot tubbed 2 fact witnesses. And it was only by virtue and with no advance warning. He just basically told the parties, I'd like to try this, and could you line them up for this evening? And how could we say no? I mean, the fact that it was virtual meant they were both obviously available because neither of them had to fly in to do this. It was obvious that the parties were going to do everything to say yes. If the other guy said yes, then we were going to say yes, have to say yes as well. So, and it worked. I mean, your question was about quantum. Honestly, that fact witness hot tubbing was more successful in reorienting at least my view of the case, because I'm still waiting for the award, than I had expected. And it was an extraordinary example of the power of virtual hearings that may go beyond hearings in presence. So the jury's still out on the outcome, but in terms of the way we reacted to it, I thought it was an extraordinarily, actually more effective than perhaps it would have been in person. Interesting.
So, Ronnie, as the expert, have you ever found that either hot tubbing or joint reports, or I guess the joint calculations or methodologies, have made significant progress on the damages issues in a case?
Joint reports, definitely not. I mean, I think I've had experiences where we've been in the room for maybe 25 minutes and said, okay, let's cut to the chase. Is there a single point in my report that you actually agree with? And the other expert has said no. And we say, okay, well, we may as well just give it up sort of here and there. Hot tubbing, I've seen it done, but not. I think, again, it all really comes down to the arbitrator preparation, that it's something that you get the feeling that it's something that could work well if thought was given in advance to what exactly is it what we want to get out of this. But if all that happens is you end with the 2 experts regurgitating their existing reports, that really doesn't sort of advance sort of anything. Models, yes, I think so. I think the slightly sort of scary thing about the well, sorry, let me take a step back. The great thing about the joint models is it does give the arbitrators obviously the ability to sort of say, okay, this is a set of assumptions I want to work with. You do worry that there's a bit of cherry picking going on. So in other words, that often the assumptions that one expert makes, they come as a package, and once you actually sort of split that package up and say, well, you have to take this assumption from this expert, but then this assumption from the other expert, there's a danger that those 2 assumptions are inconsistent, incompatible, whatever you want to say. So I certainly wouldn't sort of rule them out sort of completely, but I think, again, care does need to be taken in terms of how they're actually used.
Bianca, what have you found with hot tubbing, with joint reports, with joint methodologies?
Yeah, I'm actually a believer in hot tubbing, I have to say. I have really made excellent experiences with this type of examination of experts and also of fact witnesses. It really requires excellent preparation of everyone, because you have to react so quickly, and the scenario is a lot more uncertain, I think, compared to the one where you just ask one person. But my personal experience is that you really get more to the truth and to the really decisive points than with separate examinations. I had not the pleasure yet, I have to say, of a virtual hot tubbing, so that would be then the next challenge. But so the usual oral hot tubbing, I like it a lot. I have never done joint expert reports. That was a question which was asked several times, but I always refused, and personally, to be frank, I'm concerned that I would lose control of my expert to some extent, and so I really prefer that the reports are prepared separately, and that you do the joint exercise then at the stage of the hearing.
We heard one comment this morning from one of the arbitrators saying it would be good to be able to consult the experts separately from the counsel if it just relates to calculations. I must say, as a counsel, that sent shivers down my spine in terms of how you make the divide and what else, if anything, is being discussed. But what's the reaction to a tribunal consulting damages experts, even only on calculations outside of the presence of counsel? Karl?
I love that idea. I think it's fantastic. I think it basically that, with all due respect to my good friends who are counsel, I think you're part of that problem. In other words, you're trying to filter and control the message of the damages experts. And from my perspective, as much as anything else, I'm trying to resolve a dispute. I'm not just trying to win a dispute. In other words, you have different economic incentives than I do. You want to win the case, you want to put it on your website, and you want me to hire you again because you made us so much money or you saved us so much money. I, as much as anything else, want to resolve the dispute. And if that external contact leads to either a signal, a good signal or a bad signal to the parties about an available settlement because it indicates what the tribunals are thinking, or even given my approach to experts in general, they've been on the team in some cases longer than the counsel has. And they can act as, if you will, kind of an advocate for my position, because they do know me, they do know the industry, they know they can dynamically anticipate what essentially is what's the industry or the aerospace approach to this, et cetera, in a way that very often the experts who are appointed by the other side cannot. And so I personally, I love the idea. I have never tried it, but as long as it's done in a transparent way, I am for it.
Ronnie, have you ever been consulted separately by a tribunal? Would you feel comfortable?
So I haven't, but there's an interesting point here, I think, and it goes back to almost the very first thing that you said, to Caroline, about the comments about arbitrators not being numerate, and this concept of we'll talk to the experts only about the calculations. I honestly don't know what that means, because is it okay? Explain the mechanics of this calculation, or is it explain why you've done this calculation in this particular way? And once you get into that second sort of type of question, then you're into, well, this is the theory of harm, and I've done it in this way because this is. And so I just honestly don't know how you sort of box in. We'll only talk to you about the calculation. So I from your perspective, I see why you would be a little nervous about that, because I just don't see how you can constrain it in a way that would be that would necessarily work.
Yeah, the biggest issues in damages always are causation and the link. But maybe you could do it. What do you think, Anke, and then Craig?
I think that's also an interesting perspective to have a consultation between tribunal and expert. Although, on the other hand, I think if my expert is questioned by the tribunal, I cannot interfere a lot anyway. So I would not see really the big difference. I think finally this ties in a little bit with what I think Domitille Bézot has stated on the other panel. If I select an expert, I really want to have someone, not just a hired gun, but really someone who has a lot of credibility and really looks seriously from all perspectives on the issues, and gives also to the client really the true perspective, and takes positions which are really stable also then in front of the tribunal. And therefore, I really would welcome such a dialogue. And I have seen such dialogues, and they went very well if you have the right expert.
Great.
Well, I had the same reaction you did, Carol. I had, chills went down my spine when Doug suggested it. And, to me, it's not because advocates want control so much as we have a duty to zealously represent our clients, and I'd be concerned that if something's happening to material to the outcome and I have no role in it, is that consistent with my duty to zealously represent the client? Of course, if the client is like Karl and consents to it, that's a different situation. But otherwise, I'd be very, very, very leery to let something like that happen, outside of the council's presence. And there's been a few questions along the line, the same lines about whether the advocates have an issue with joint reports because it's a loss of control. I mean, to me, it's not so much a loss of control. I've just found the so-called joint reports identifying areas of agreement and disagreements to end up being just a recitation of disagreement on 90 to 95%, and just a tiny portion where the experts, come to some sort of common ground. So that's why I think it's not useful. Not that it's not conceptually a good idea. I just find in practice it's just not very useful. Maybe that's just been unfortunate in the cases I've been involved in, and others have had better experience with it.
I must say that I've had the same experience. Experts can devote 2 to 3 days trying to come to some terms, and you look at the end result and it's almost nothing, in terms of agreement. I don't know. I don't know what the motivations are, but we only have a few minutes left. So I want to turn a bit to the question of after the hearing. Then what is what do users and counsel and experts want from the arbitrators? And to me, we've seen play out in a number of cases, certainly in gold reserve. What the tribunal did is after deliberations, after they came to a kind of conclusion on liability, they returned to the parties and said, okay, here's where we are. You can't debate that, but could you address or even change the way you approach damages as a result? In terms of due process, I find, that is probably the best approach because the parties get to address it. But obviously, in terms of cost, in terms of time, there are all kinds of issues. In a big case, I would tend to want it, but I want to hear each of your views in terms of when the tribunal has done enough deliberations to figure out where it's going to end up on liability, instead of just choosing a damages methodology that may or may not have been addressed. What would you prefer? Should they come back to you and have you address the point then? Craig, what do you think?
It might depend in part whether I was the claimant or the respondent, or the burden of proving its quantum case. But as a general rule, I would think that if the quantum case that's been presented to the tribunal doesn't fit its ultimate decision on liability, whether that's because that decision wasn't really foreseeable, or it was just too complicated to try to come up with a quantum model that would address every single, possible liability finding that the tribunal would make, and that can be the case in complicated cases that involve, for instance, maybe a lot of regulatory changes, some of which might be considered a breach of a treaty, for instance, and some which might ultimately not be found. Then I think it's good practice to give the parties an opportunity to represent quantum in the context of the liability findings, and I would be in favor of that, I would say most of the time, not all the time.
Karl, any observations?
Yeah, I think inherent in the question is what I would expect and like from the tribunal most of all. In other words, the willingness to put a pride aside and say, despite everything we heard, we just don't get it. There's something we're still not sure about. And I say that, not as an assumption, but as a genuinely useful critique of the parties having presented these models. If the tribunal doesn't understand, rather than trying to muddle through, and I've seen in awards something that doesn't resemble anything that's either the parties posited or even common sense, sometimes that indicates that they genuinely didn't understand, but they didn't do anything about that either. And so asking the question, whatever the question is, serves two useful functions. First, it gives the parties the feedback that you didn't explain it in a way that we understand, and ultimately it's your burden to make us understand it. And the second thing that it does is I want that signal. I mean, one thing I do with my quantum experts, with my fact witnesses, with my counsel is point to them individually after the hearing and say, please tell me if you heard anything that gave you pause, gave you concern, something that you hadn't taken into account, whether you acknowledged it on the stand or in your advocacy or not. I want to know if there's something that you're worried about that you weren't worried about before, because it's not too late for me to reach out and try to settle. By contrast, if you heard something the other side should be deeply concerned about that you hadn't thought of before, tell me that too, so I can reinforce my position. And if the tribunal reaches out, look, we're the film's in the can. We're at that point on our way to an award anyway. This gives us a last chance to reconsider our positions as parties and find a settlement we can live with that doesn't require the award. So from either perspective, I think that's a great idea.
Ronnie, as an expert, what would your view be? Would you welcome the opportunity to address, no matter what side you were on, the damages in the context of where the tribunal thinks it's going?
No, absolutely. I would much rather have the opportunity to revisit the question than have somebody take a report that was written under one sort of theory of liability and then try and somehow morph it into a report or a damages number that fits an alternative theory of liability. So again, acknowledging that there are definite costs involved, but would certainly appreciate the ability to do that.
Anka, have you dealt with this, and what do you think?
I can, of course, refer to the example I provided you in our first round of questions. And I think that is exactly the scenario you have described. But the tribunal was not prepared to really admit that it had not fully understood the matter and that it needed further help by the experts. So, of course, I really would welcome here the initiative of the tribunal, although as a party, I would clearly prefer that the tribunal does its homework before the hearing and at the hearing at the latest. I also think such instructions can be very useful also in terms of giving the parties a clearer picture where they stand and then maybe even enable settlement proceedings. One issue that I see is that if, for example, the tribunal asks the experts now use a new methodology or base your expert report on another assumption, then this is not just done by one brief, because then the other party also needs maybe a chance to respond to that, and that really can protect the arbitration proceedings. But I think it's of course still better than have a late bifurcation and a partial award and a second phase of the arbitration proceedings.
Is there anything else that you would like to see go on between the arbitrators and the parties and their counsel after the hearing, even if it's written inquiries and not another hearing or whatever? Anka? No.
Yeah, I'm general really a fan of questions of the tribunal pre-hearing, but also post-hearing, because it really helps counsel and parties to focus on the really important issues or on the issues that the tribunal has not yet fully understood.
Yeah, and if tribunals in those written questions identify what the essential damages issue is, it's the best way to go out to the parties and ostensibly get a joint report. The damages experts may or may not ever agree, but at least you'll have very synthesized views on exactly what you as an arbitrator need, and certainly that's what the parties and the counsel need. So any other observations? We're right at 10:30. I'm just watching the clock. I don't want it to end. I think you've all been fabulous and have some great different dynamic views, but it is 10:30. Well, wherever you are, it's the hour. It's 15:30, 10:30. Okay, I guess we're going to be broken into our groups again, but I thank you all very much for being dynamic, engaged, and for all of your excellent observations. It was a very interesting contrast to watch between our views as counsel users and experts from the arbitrators' views. But thank you very much.
Good afternoon, everyone. So my name is Theau Laurent. I am a partner in ICAEW's London office, and I am a quantum expert. I am delighted to be moderating this last session for the day. I think we are very fortunate to have, again, a fantastic panel for this session, not only because of each panelist's professional achievements, but also because the combination of their profiles would allow us to benefit from the perspectives of different types of participants in international arbitration. And so let me briefly introduce each of them, starting with Dr. Andrea Meier. I hope I pronounced this correctly. Andrea is a partner at Walder in Zurich who practices both arbitration and litigation. She has been involved in over 70 arbitration cases as either counsel or arbitrator, and she is recognized as a global leader in her field by Chambers Global, Chambers Europe, and Who's Who Legal. And she is a member of the board and executive committee of the Swiss Arbitration Committee, of the Arbitration Court of the Swiss Chambers Arbitration Institution, and of the German Arbitration Institute Appointing Committee. Next, we have Roula Harfouche. So I personally know Roula very well, having worked with her during a number of years and up until very recently. Roula is now a partner in HKIAC in London and a fellow of the ICAEW. She has over 20 years of experience in performing valuations in a variety of contexts and has particular expertise in the assessment of damages in both international arbitration and litigation cases. and she is recognized among the leading expert witnesses by Who's Who Legal in the Thought Leaders Global Elite lists, nothing less. Next, I'll very just remind everyone who Karl and John is, because they were obviously on previous panels. Karl is with us on this panel again, and Karl is Senior Vice President and Head of Litigation, Investigations and Regulatory Affairs at Airbus. And last but not least, we have John Fellis, who is now a full-time arbitrator, currently in New York. Before we go into the questions, I'll briefly reiterate a few housekeeping matters which were set out at the beginning of the event. But maybe just for those participants who have just joined us, we have received a number of questions in advance, some relatively broad, others more specific, which I will be putting to the panelists. Further questions can be asked, I understand, using two features, either by typing them in the chat box, which you all have on your screens, or by raising your hand virtually, that is. I think there's a little button that allows you to do that too on the screen. Finally, we thought it would be interesting to benefit from the delegates' views on some of the questions, so we will upload a few polls on the platform. And we would be grateful if you could answer these when they appear, and we will show the results as we discuss the corresponding questions. So now turning to the subject matter, the first set of questions we received pertain to the framework under which damages are assessed. And the underlying theme seems to revolve around the need for further guidance when approaching damages, because that framework often remains open to interpretation, and awards are not always consistent in that matter. And so the first question reads as follows: what are the panelists' views on the application of ex ante versus ex post information in the calculation of losses? In other words, assuming the relevant contract and applicable law do not provide any concrete guidance on this point, should the tribunal only take into account information that was available to the parties at the time of the event giving rise to liability, or should it also take into account information that only became available subsequently? Now, I believe this question is quite topical because obviously the valuation date and correspondingly the information relied upon could have a significant impact on damages, depending on whether or not one takes into account the current sanitary crisis. Karl, would you like to take this first question?
I'm immediately attracted to the example that John Fellis gave in his earlier remarks about the yearbook of Janis Joplin. Being a big fan of Janis Joplin and having no opinion at all on Lady Gaga, I would say that it's tempting to use that as a justification for a purist view. It's just not fair to essentially blame an individual for the subsequent events. But I think that the exceptions overwhelm the rule. In the sense that you are going to find that, especially in reference to the sanitary crisis, failure to take into account COVID is going to be deemed by tribunals as rendering an award so vulnerable to due process challenge by one form or another as to essentially be an unrealistic standard. And in that sense, we're all going to be charged with the need to deal with, even if we don't agree with the standard, the potential for windfall in either direction, positive or negative, and therefore anyone who would choose on a purist point of view to ignore the white elephant in the room is simply not being realistic and is taking chances that I think no counsel can reasonably take under the circumstances that we're likely to face when calculating damages arising out of the COVID crisis.
Thank you, John. I could see you nodding. I'm assuming you are in agreement. Maybe I'll take that as a yes. Maybe Roula, can you give us your point of view as an expert?
Yes, no worries. I was going to say, that, John, did you want to intervene before me? Or are you okay to do it afterwards?
Oh, you go first, Roula. I think everyone's heard enough from me, and it would be nice to hear from you and Andrea.
Okay. So for us experts, usually the date of valuation is a matter of instruction. It's not something that we decide, but we can help with showing what the different options are, what the value is going to be, what the pluses and minuses are, the strength of weaknesses of using different valuation dates. A couple of things maybe that will help is there's often confusion between value and lost profit. And so it's important to set what is it that you are asking us to assess. And there's often confusion, apologies, but on the part of the lawyers and the tribunals on that. So a loss of profit is something that a company itself can claim. A diminution in value is what the shareholders or the investors in the company can claim. And so you need to decide who's the claimant and what we can calculate for them. There's also a couple of things to remember. I think there's been a bit of misunderstanding about the reasons for the differences in value, particularly in investment treaty cases, between ex ante and ex post. And often people think that the difference in value is due to, for example, the application of pre-award interest in bringing forward a valuation that was done at the date of expropriation. That's not, in my experience, the main reason for the difference. The main reason for the difference is to do with the assumptions that you put in. So the typical example is the ADC case, the Hungary airport. And the main reason for the difference was that they had their forecast wrong. So as at the date of breach, everyone expected, I think, much lower passenger numbers than ended up being the case. And so if you move your valuation forward and you take into account the actual number of passengers, then your forecast as at the date of the award, which I think was 2006, are going to be much higher than they were at the date of breach in 2002. So that's the main reason. The second reason why you have differences is what you do with what is called euphemistically the past losses. So you're standing in 2021, your date of breach was, say, 2015, and between 2015 and 2021, you've had past losses. But those losses never happened, so you don't actually know what they were. And some experts will treat them as certain, so they will just take them and then they'll add pre-award interest to them, so inflate them going forward. And some experts will say, but wait a minute, these are not known. But it's true they're not known themselves, but a number of uncertainties surrounding them have been resolved by the passage of time. So if you use hindsight and you sit at the date of the award, they are not as uncertain as future losses post 2021 in my example. So you cannot risk weight them fully either. And so you have to find some sort of intermediate solution, which is not based on corporate finance theory or economics, which are all forward-looking. They're not catered to deal with past valuation dates. Does that make sense? So these were my main observations there.
It does, and I would tend to agree with you, Roula. As much as hindsight reduces uncertainty, it rarely eliminates it, and it has to be dealt with accordingly. You touched upon the ADC v Hungary case, and that sort of segues well into the second question, which is related but more specific to investment treaty cases. And the question is, would it be a good idea for investment treaties to set out rules on the assessment of damages for treaty breaches? If so, what changes to the general legal principles as embodied in the ILC articles on state responsibility and the Chorzo factory dictum states could or should consider / explore in this respect? Now, before I I'll put this question to the panelists. I think we have a poll on this. If we could have it up. There, fantastic. I'm realizing I need to take part of this on too, because otherwise that won't go away. While we wait for the answers to come up, Roula, do you mind then continuing on your previous answer, but dealing more specifically with investment treaties?
Sure. I think the two questions are a bit linked, at least in my mind. So again, as a damages expert, I would love to get more clarity on this. I would really like to have some clear rules as to what we are assessing and as at when. I've got the results here.
The results are up, and it's very, very, very even. Given that we have a majority of experts, I think, attending the conference, it's quite interesting. Carry on, please, Roula.
Yes. So in commercial disputes, the rules are fairly clear. Normally, you assess either loss of profit or diminution in value as at the date of breach, without using hindsight, minus certain exceptions. And Karl mentioned the sort of the elephant in the room. It's difficult for a tribunal to just ignore what happened afterwards. But these are the basic premises. It would be helpful to have an investment treaties clear rule as to whether you're valuing damages, and the damages are from the point of view of the claimant, whoever the claimant is. So they take into account the specific circumstances of the claimant. So if the claimant has advantages or suffered from disadvantages which are not the same for everyone else on the market, you take them into account in damages, not in the alternative, which is the FMV, the fair market value. It's not always defined in BITs. When it is defined, it is the value that's, or the price that would be agreed by a willing buyer or willing seller. So we're not taking into account the specificities of the claimant in this case. And this is the main difference between them. So for us, this is one of the main causes of those huge differences that are often complained about between the valuations of the claimant's expert and the respondent expert. So any clarification would help us to narrow that gap.
I would tend to agree too. John or Andrea or Karl, do you wish to add anything to this?
Yeah, I think it's an excellent analysis of the problem that overwhelms the rule. I mean, it's referring to no one in particular considered the problem of evaluating the damages to a buyer of a large civil aircraft that can claim breach for failure to deliver that aircraft due to technical and certification problems in the grounding of the aircraft prior to the COVID crisis, and consider the effect on the damages that might be claimed of the subsequent catastrophe that befell civil aviation and completely changed the picture about the desirability of having aircraft in one's fleet as a result of the travel restrictions.
Yes, I think there is this common distinction in most BITs and there between lawful and unlawful expropriations, and the lawful expropriation for lawful expropriations, the guidance provided by the BITs, as Roula was suggesting, is the fair market value of the asset at the date of expropriation. And for unlawful expropriations, then we revert back to the principle of full compensation. And what happens is we are, as experts, often instructed to sort of reconcile both concepts, which essentially shouldn't be, I mean, theoretically can't be reconciled. John, as an arbitrator, anything you wish to add? Or Andrea from...
Yes, maybe one point I would wish to add from the perspective also of the arbitrator. I think what is important here for us is to have transparency. We have seen now that different approaches work. It really depends on the situation. You might sometimes be invited or supposed to use ex post information. Sometimes it's a different analysis for business valuation. You may only be allowed to use ex ante information, or there might be a hybrid approach. But then it's always important to really clarify the information that you use. Is it ex ante or is it ex post? So that will just really allow for the tribunal to make the right assessment. So that's my call for really clarity in that regard.
So I think everyone on the panel. Sorry, go ahead, John.
No, nothing more from me on this topic. I agree with my colleagues.
I think everyone seems in agreement, although the poll does suggest that opinions are much more divided than that of the current panel. The last question in relation to the framework refers to moral damages, and the question is, in relation to the issue of moral damages, how frequently are they claimed and awarded? What is the basis to claim moral damages? Is there an example of a case where the tribunal considered this issue? So a bit more specific. Andrea, could you share with us how such damages would be approached under Swiss law?
Yes, I'm happy to. And I also looked at it in a bit more broader sense, not only from the Swiss law perspective, because I was quite intrigued when I researched for this question, because I discovered huge differences depending on the applicable law. And that is quite astonishing. It can make a huge difference in terms of the sum that you could be entitled to under this title of moral damages. But let me address this first, particularly from the angle of commercial arbitration. The discussion is a bit different in the field of investment arbitration. So if you look at commercial arbitration and then again civil law, we should be aware that moral damages in the civil law tradition are considered compensatory. So they are intended to compensate a wrong to an individual's emotions, honor, or reputation. So moral damages are not considered punitive damages. And I think that's an important distinction. Now, on the Swiss law, and I understand the situation is similar in Germany, Austria, France, and Italy, it is possible also for companies to claim moral damages. And that's the case if there was a serious infringement of their personality rights. And the most common case that you see is a conduct that would harm or has harmed a company's reputation. And similarly, the right to recover moral damages is explicitly set out under several civil codes in the Middle East, including Egypt, Libya, and Lebanon. And that said, as I have already mentioned, despite this, what looks like common ground, the result may be very different. And I'm now referring to a specific case that I found, and that's an award that was rendered by an ad hoc tribunal in Al-Kharafi and Sons Company versus the government of Libya. So in that case, the tribunal awarded $30 million to the claimant for reputational damage. And it did so based on a provision in Libyan law, and because it said it's a compensation for the damage caused to the claimant's reputation in the stock market, as well as in the business and construction markets in Kuwait and around the world. That is interesting. It's a substantial amount. And now if you turn to Swiss law, the picture is totally different. Decisions awarding moral damages under Swiss law to companies are very few. And if so, the amounts that you will get are very modest. Now I'm speaking of amounts in the range of 25,000 Swiss francs or maybe 50,000. I found one case where a modest amount was awarded to a company because of defamatory comments about the company on a website. If you look specifically for international arbitration cases with tribunals seated in Switzerland, the cases are even rarer. I found one example where moral damages were claimed in the context of a breach of a consultancy agreement, but this request was ultimately denied. And I assume, we don't know the reasoning in that regard, but I assume it was because claimant could not show that there was an infringement of its personality rights. So to sum up this little analysis, I just wanted to create awareness that there can be huge differences, even in the civil law area, depending on the applicable law. And that seems quite remarkable. If you look at investment arbitration, we have a different discussion there. I understand there what we can observe is a little bit of a shift from a compensatory approach to a non-compensatory, more punitive approach. That's interesting, but I'll stop here.
Okay, thank you. That was very exhaustive. Thank you, Andrea. I personally haven't, as an expert, haven't come across them that often, if I'm being honest. John, is there anything you could add to this?
Yeah, yes, I could. I think one starting point is I practice in the United States, where punitive damages are a common phenomenon, but also statutory damages. And that is, for example, if you have willful infringement of a patent, you can get double or up to treble damages. Willful infringement of trade secrets, you can get double damages under some state laws. I've had a few cases under Massachusetts law where almost inevitably there's a claim under something called Chapter 93A of the Massachusetts general laws, which prescribes and awards, I think, up to treble damages for deceptive conduct in business. I'm sort of putting it more crudely than the statute is. I have actually had one case where I was counsel, where we did obtain double damages on willfulness grounds. And, I'll just tell you, it was an international arbitration. I'll just tell you very briefly, the facts. It was a typical scenario, actually. Our client manufactured a medical device. It was approached by a competitor in another country, essentially saying, we would like to buy you, or we may be. So they signed an NDA. They exchanged all sorts of information. Then more information was exchanged because they wanted to do their due diligence. And then, of course, the agreement was terminated. And a year later, they came out with a competing product. And we were able to prove willfulness because one of the things that was exchanged was the source code for the software that operated the medical device. And there were portions of it that were verbatim identical, and there was no other explanation for that, at least according to our expert. And I think the tribunal were convinced it was willful. In other words, they it was a plan from the beginning. So I felt this was punitive. I mean, in the sense, this wasn't compensatory. The compensatory damages were fixed. This was double to punish for willfulness. And it's the one time I've seen it in an international case. Punitives are, frequently sought in arbitrations, especially in the United States. But I've never seen punitive damages as such granted.
If I may make a practical observation, Anthony, just very briefly, I find there is an inverse proportionate relationship between the size and sophistication of the claimant as respondent, or the size or sophistication of the lawyers representing the claimant, and the likelihood with which they will claim moral damages. It is almost characteristic of, shall we say, the unsophisticated party whose emotions are really at the heart of the source of their claims, or the unsophisticated or less courageous lawyers who should talk them down from the ledge of those emotions. I find, practically speaking, almost the only time I see moral damages claims are in those specific circumstances. And in the hundreds of awards that I've seen over the years, I've seen it granted only once. And it was for, as Andrea pointed out, a very small symbolic sum. And it was clearly a sort of a parting gift by the sole arbitrator to a party for whom they felt a certain amount of sympathy, but not enough sympathy to overcome the defenses to the main claims that had been made in the arbitration, reducing the actual damages to a tiny fraction of what had been initially claimed. And it was almost like there was kind of a little bit of, call it insurance against a potential annulment proceeding, call it sympathy, call it what you like. But honestly, we didn't feel too bad about paying it, just because it was so small and so symbolic and so rare that it was almost a curiosity.
Am I right in thinking that moral damages can only be given to people, physical people, as opposed to companies?
No. It can be awarded to companies and enterprises as well.
It might. I think that's really the general rule. I looked into that, however, because it has been contested and criticized under Swiss law. It was a huge debate because they say, commentators have said, look, companies are not people, they cannot suffer. Who suffers there? And so it was sort of narrowed down to really reputational issues where the company could suffer financially, basically. So it's more limited in terms of the application.
Thank you. I do apologise. I'm slightly conscious of time. I think I have to move on because we've done 3 questions so far. Before we move on to next topic, I got a question from the chat which I thought I should bring up, and I will read it out best of my ability. I am curious what the thoughts are about a case where one expert provides an opinion on value with an extensive report, and the opposing expert merely makes adjustments in a short report to that opinion rather than formulating their own independent opinion. As valuators in Canada, this practice is inconsistent with our professional standards, but nonetheless is common in practice, likely for reasons that are broader than the damages analysis, i.e. strategic, budget, etc. Does anyone have a particular view on this? Or I will
sounds
arbitrarily...
like another way by which a joint report might be generated. In other words, it's if ordered by a tribunal, if attractive to one of the parties, that it sounds basically like a kind of joint report.
Well, I think that the issue is
Sorry, go ahead.
I was going to say, I think the issue is that the other experts, the opposing expert in this case, relies on the work of the claimant's expert and only making a few adjustments, if I'm reading that question correctly.
And can I maybe jump in here? I think it's a very good question because it raises an interesting point on the aspect of the burden of proof, because who has to establish and quantify the damage? So on the Swiss law, it would be for the claimant. And that then triggers the question, what actually is the obligation of respondent in that regard? Of course, the respondent can challenge that calculation and would normally do so. But does respondent really have to? And I'm just raising now the question because I have not thought it through, but this is good. I think they don't have, frankly, I think it's the burden of proof is on the claimant. Or if it's claimed damages.
Sorry, John, go ahead, please.
Well, I was going to say, whether an expert has an obligation to supply an independent opinion, I suspect may be a matter of the law where the arbitration is taking place and his or her professional obligations. But putting that aside, just as a practical matter in this type of scenario, and I think it's a great question, the model advanced by the first expert is the model that's going to be adopted by the tribunal because that's all they have. And sure, there may be some tinkering around the edges, and it's possible that the tinkering will be substantial or not. But you're essentially conceding that model to start with, just as a practical matter.
It seems to me that if you're just making adjustments to, let's say, the claimant's calculations, then you accept the premise, you accept the model they've used, the approach, and you're just disagreeing with a few assumptions. And again, it's tactical, but it may be very helpful to the tribunal, as Karl said. In my experience, I've seen the other extreme, which is where the respondent's expert is asked not to give an opinion at all. So just criticize and don't present anything positive for to help the tribunal. It's obviously not our job. We receive instructions, but I try very hard to dissuade my counsel and client from doing something like that because I think it's unhelpful. And ultimately, you, the expert, look like you're not doing your job and trying to help the tribunal, and that reflects badly on your client's case, either way.
It's also very risky. It's also very risky, for a tribunal only to have one model, and maybe there is only one model. There are going to be cases where the experts will agree, but it strikes me you really are the side that's not putting forward an alternative is really giving up half of the fight, and maybe it has to, but that's what it's effectively doing.
or maybe it's so sure it's going to win on liability that it doesn't want to engage with quantum. But it's a risky strategy, as you say. Who's ever?
That is a whole nother story, which I really think people should avoid, because people do that. They say, I'm not going to dignify the other side's damages request with a response, and that's also a risky strategy. Because
I would go so far as to say that there have been cases, rare as they are, where I've been willing to stipulate liability and fight only on damages, but there's never been a case where I was so sure of my liability theory that I effectively said, damages, who cares, or just pick around the edges. No.
I think that's what happened recently in the PNID versus Nigeria case, wasn't it? And tribunal awarded claimants over 9 billion of damages solely based on the claimant's experts, because respondent had decided not to put, not only because, but partly because, that's debatable, respondent hadn't put forward their own theory on damages. I guess that's a good illustration of the risks if you don't put forward any case on damages. Again, in the interest of time, I suggest we now move to the slightly more technical topic of valuation methods and damages model. And the first couple of questions we have received stem, I think, from the fact that damages calculations are increasingly data heavy and frequently now leading to more complex assessments. And the first question we had on this topic was the following. Are arbitrators keeping up with more data-driven / technically complex damages calculations? How can damages experts better assist in this area? Again, before I hand over to John on this one, I think we have a poll too on the first part of the question. There you go. And then, John, you may proceed. You're on mute.
Andrea, did you want to say something on this? Because I noticed you had marked this off on our list, but I'm happy to go ahead. If not,
feel free to go ahead, and then I'm happy to follow up.
Well, I mean, I think that, just to answer the question crudely, I think it's very hard to generalize about what all arbitrators do. But, I just speaking for myself, do try and keep up with this. I think damages experts, I think it, to some extent, to help the damages experts can give, it falls to the tribunal to make room for it in the schedule in order for them to do that. And I don't want to sort of go over old ground that have been covered by the first two panels about how arbitrators should do that. But it just suffices to say that this whole notion of leaving things till the end and having the experts testify on the last day when there's only a day left because the whole liability case is taken longer than everyone thought, I think is a huge mistake. I was intrigued by Karl's notion of in the previous panel of reverse bifurcation. I recently had an application for that by the respondent in a case, which I suspect is typically how it would come up. And the claimant was very, very resistant, and it was very, very resistant on the following grounds. Our liability case is so strong, it makes they didn't quite put it this way. It makes the other side look like such bad guys. We want you arbitrators to hear the liability case first, before you hear the damages. And so in the end, we did the simpler thing, and we didn't bifurcate in that case, partly because we thought it was better to have a full record. But it may have been the alternative decision were the better one. But anyway, when you were talking about that, Karl, that was my reaction.
The polling results overwhelmingly say that arbitrators are not keeping up with more complex calculations. Andrea, did you want to step in?
That's an encouraging result for arbitrators. But okay, I think it's acknowledging a reality, because what happens is, as an arbitrator, you receive 2 rounds of full submissions by the parties, accompanied by several expert reports often, and these expert reports are hundreds of pages and with plenty of appendices, very difficult calculations, so it's a lot to digest, but we have to. I mean, it is our duty. We need to digest this information and we need to understand it. And for me, the phase before the hearing and the hearing is really crucial for that. So we have to there really use the methods that are out there to try to identify, not only try, but to identify the crucial issues. And to me, I find that 2 methods are particularly useful for that. And one is asking for a joint list of issues before the hearing. Now, I'm not talking about a joint report, because I share the view that this is a huge task and the outcome is so-so. But just, simple list of issue table can be produced by counsel together with the expert, setting out the issues, and in a table setting out common ground or know why to flag the issues. And then you can take that to the hearing as a sort of roadmap. Point 2, other method which I think works well is expert witness conferencing. It was a bit criticized before, some critical voices, because of course it can be a waste of time if it's not employed correctly, but it can be very helpful to the tribunal if it's done in a structured session. I would say following the presentations and cross-examinations, looking at really then the issues that are still unclear to the tribunal, because the tribunal has listened to the discussions and should then be able to identify where do they still struggle. And they should be honest about it and have the experts there go through the issues and really clarify them and insist if they don't understand. So to me, that can be really powerful.
If I may add to this, I know that hot tubbing was criticized and joint statements were criticized. In fact, I've had horrible and good experiences with both. So a joint statement can be perfect, can be really, really helpful for the tribunal when you have what I'm going to call a reasonable expert on the other side. So the issues, the differences between the experts are not fundamental. They're not about approach. They're not about, say, data valuation or valuation method. They are about specific assumptions that go in there. Then it can be really helpful for the tribunal because you can set it out, explain why you think this is the right assumption, why they think so, and what happens to the damages or to the value if the tribunal takes different combinations of assumptions. So they can be really good. I have one at the moment where the other expert is simply not speaking the same language, so it's completely useless. And we're going to end up in another hearing, just so we understand what we're talking about. And hot tubbing, the best one I've had was a surprise sprung by the tribunal. Again, I think, John, you talked about it in the previous panel. So we finished being cross-examined, and they said, "Oh, well, why don't you stay where you are?" And the other expert, "Please come back, and we'll ask you some questions." And it was brilliant because we weren't prepared. We didn't know. Our counsel were terrified, both sides. They hated the whole thing because they were surprised. But the tribunal got honest and unprepared, unrehearsed answers from us, which they found very useful. And they went to the bottom of the issue. And from an expert's point of view, when the tribunal asks you a question, you answer them. You answer them correctly. You answer them in full. And you answer them as openly and transparently as you can, because this is your one chance to influence the tribunal. Cross-examination questions are different.
It strikes me, Roula, in that case, the tribunal were prepared by the sounds of things.
Absolutely, they had their questions. They knew exactly what they wanted to know, so they had prepared those in advance, I think.
Which is, I think, hot tubbing is only useful when the tribunal have done their homework. When they haven't, and when it's a sort of a casual, let's put you together and see what happens, it's really sort of random.
Yeah, and different personalities of experts tend to dominate, and that's not the purpose, because you can have someone very, with a lot of gravitas. I'm going to use the G word, but fundamentally the content of what they're saying is not right, and that can over-influence the tribunal, unfortunately.
Can I ask a question to Karl? Karl, I sort of heard you speak about. Sorry to take over your role, Anthony.
Please do. That's absolutely fine.
This notion there should be more of a focus on damages, and certainly sometimes you're willing to stipulate to liability and go straight to damages. But what about a case where you have a strong liability case? Don't you then worry that focusing too much on damages is going to be a waste of time, a waste of money?
Well, I mean, it's interesting because just as we were talking about that, I was thinking about a case where I thought we had an absolutely ironclad liability case. In fact, it was so strong that I think I was guilty of assuming that the damages point would be influenced by the strength of the liability case. Laurent Lévy, who was sitting on that tribunal, asked a damages question, which was the only question that really mattered, which was, what was the accounting treatment that you gave internally to the damages that you are now claiming? And essentially, the whole thing fell apart in front of our eyes. I mean, there were elements of the claim that did not depend on that, but a great deal of the claim did. And it was because I think we were so focused on the strength of our liability case not quite to the exclusion, we had a strong damages model as well, that none of us had got to ask that question. And in fact, the other side, who was so terrified of our liability case, hadn't thought to ask it either. But because Laurent was so prepared on the damages question, he did it right then and there. It didn't resolve the dispute, but it sure narrowed it. And at that point, we could make preparations for what was inevitably coming, et cetera, because he was focused on damages when claimant and respondent were both too focused on liability because the liability case was so one-sided.
Thank you, and I think it's not because damages calculations are getting more complex or more data driven that the disagreements between experts cannot be narrowed down to a number of say main disagreements. And that sort of segues to the next question. I do apologise because I certainly need to move on, although those conversations are very interesting. And the next question is, what level of detail is appropriate for damages presentations to arbitration panels? Is it better to present damages in extreme detail, or is it better to provide summary level detail and let the panel or counsel ask questions to drill down? You have the poll that has come up on your screen. And Andrea, would you mind taking this question, please?
Yes, I'm happy to. I would say, to me, in my experience, a summary level detailed presentation is more useful, at least as a starting point. I mean, for the tribunal, they really have to understand the issues, get the big picture, and then you can work from there to a more detailed level. But also as the expert, I think you need to get a feeling where the tribunal stands and what are the problematic issues. Because otherwise, if you start with a very detailed presentation, you may spend a lot of time on issues that are not really problematic. Whereas you should really focus on where is the problem, maybe also for the tribunal. And I think starting with a summary level, that presentation allows you to see where the issues are, and then you should employ, as an expert, a flexible approach, I would say. You should go along with what the tribunal needs. And you see from the questions whether you need to provide more details. So I would advocate for a tailor-made approach, but not starting off with a detailed presentation. Also considering that the tribunal already has the written expert reports on file, and you should expect them to have at least read them.
So majority of both, I suppose. but still a significant proportion, I think, went for very detailed, which I personally would tend to disagree with and agree with you, Andrea, in that starting with the summary of the approach and certainly the areas of disagreements, which can always, in my own experience at least, be narrowed down to a few, at least the main ones, the ones with the most significant impact on damages, is often most useful and sufficient. Any other panelists, Roula, Karl, John, want to add to this?
Just a very quick comment. When you say very detailed, of course, it depends on what the details are. There some damages expert reports will have 50 pages just about the facts of the case, and it made sense in a day when direct testimony went in orally, and you wanted the expert to be able to tell the whole story and tie it together because she or he was the one person who could, but it just doesn't make sense now. The arbitrators know the facts because they've learned it from the other submissions, and they don't need it in the expert report. But other than that, I think it's good to combine some sort of summary to give the arbitrators a roadmap of your analysis, and with the more detailed analysis.
Thanks, John.
Can I say a couple of things? In my experience, something quite naughty is done by some experts where they waste a lot of time on assumptions that don't make a difference to the ultimate number. And that's one of the tricks. So I find it helpful when you can, at the beginning, focus on the assumptions that do make a difference to value. And so these are the ones that you want to get into a bit more detail, or a lot more detail, depending how important they are. And for the others, you can put them in summary form and refer to an appendix, and no one will probably look at it because it doesn't matter to value. But one of the techniques to waste everyone's time is to, spend a lot of time on assumptions that make no difference at all.
And can I ask, why would they do that? I mean, what do they hope to achieve by using that technique?
I think it's to waste time, to not allow people to focus on their weak case.
Well, if I may, I think that's even a generous interpretation. In some cases, it's a smokescreen to distract from a weak position on an assumption that actually does make a big difference. If they can treat all assumptions as being equal, then they hope that they can essentially elide the point about how fundamentally destructive a certain assumption is to their theory of damages.
I completely agree, Karl. We had, I think we've got 10 minutes left, so we had other questions which were very specific, which revolved around the use of Monte Carlo and damages in relation to trade secrets. If that's okay with everyone, I'll push them to the end, because I want to make sure that we can at least briefly discuss the last two topics. And I do apologise for the delegates who have sent those questions around. But there's the usual suspect now, which is the current context of the sanitary crisis. And unsurprisingly, we have received a number of questions in relation to the impact of COVID-19 on damages. That's something I think we should discuss during this session. And the first question is, how do you account for / factor in the impact of COVID-19 in the valuation of damages? Karl, can you share your views on this?
Yeah, I think there are two fundamental points. One we've already touched on. It is going to challenge this debate between ex ante, ex post in a way that almost nothing has in recent years. The last time I saw anything similar was in the aviation market after September 11th, where I was dealing with a case in which it was alleged that on the basis of the ex ante point of view, having a bunch of long-range aircraft sitting around undelivered was a positive for us because there was a boom in the sale of aircraft ex ante of 9/11. We're going to see that point challenged quite a bit. We've already talked about it. The second is there is a great deal of national ameliorative legislation that came into play, and choice of law is going to become a vicious battle for quantum, in the sense that there are measures that were taken in many countries which suspended all kinds of accruals of damages, statutes of limitations, deadlines of various kinds, barred certain claims from being made. I could go on, but the attention that will be paid by clever counsel who have their eye on damages rather than just on liability to those points can make a fundamental difference. I've got one right now. It's a dispute where essentially, depending on which law will apply, it makes the difference between an excellent claim for about 100 million and potentially no claim at all, just based on the argument about whether one of the national laws that was put into place to try to relieve businesses from some of the burden of COVID is going to apply or not. So that will be the battleground. It's a choice of law point, but at the end, it's a damages impact.
Roula, as a quantum expert, how would you factor in the impact of COVID-19 beyond the choice of valuation date?
Yes, carefully. I joke, but as I said, I think when we were preparing for this panel, I've heard these questions about COVID-19 and 12 years ago about the credit crunch, and a few years before that about the internet bust. And it doesn't fundamentally change what we do. It just means that we have to be extra careful with the valuation date and hindsight, which in the normal course of business would not cause such a difference, except if you're talking years and years of difference between the valuation dates. But normally we wouldn't worry about them too much. If your valuation date happens to be end of 2019, early 2020, then and then you have the option of doing it later on, then this becomes a major focal point. So I would say be careful with your assumptions, be careful with the sources of your assumptions, and triangulating the results of different valuation methods becomes even more important than it normally is. And I would try very hard to have several methods, and then several sub-methods within the method. For example, if you're using multiples, I would try to use multiples of different earnings of different years, just to get several sort of points of comparison. And doing that becomes more important in a context such as COVID-19, where there is simply a lot more uncertainty.
So more caution, Roula, is your advice. Is it fair to say, I mean, it has to be looked on a case-by-case basis. And I think I've come across this preconception that it has necessarily a negative impact on damages, but that's not entirely, it's not always the truth, is it? If you're invested in the hospitality industry in London, then the value of your investment would have gone down significantly. But on the contrary, look at other stock prices such as Amazon, Tesla, Alphabet, they've gone up significantly too. So it has to be looked on a case-by-case basis.
Yeah. Generally, the stock market fell very, very dramatically in February, March, and then everything went up again. So we're now back to very high levels, despite, in the case of the UK, the third lockdown and break. So it's not clear at all that would necessarily reduce damages in every case.
Agreed. With the 4 minutes that we have left, I suggest that we discuss the questions we have in relation to the selection and best use of experts. And the first one is quite broad, and I will ask Andrea, how does one select the right damages expert?
Yes, and I'll just start off on that, because obviously I would also be interested in the view of Karl and John in that regard. It's just, to me, really selecting the expert is one of the most important decisions that you take in an arbitration, maybe the most important strategic decision. So it should be done really with care, and you should take the time to meet the potential experts, to have discussions with them. And I should say these should be very frank discussions. You should, with the candidates, really take the time, counsel, to go into the facts of the case and to find out what are the experts' view. You should involve clients if that is possible, and it should be. You should have also accept critical input from the expert, because at that point you should be still in an early stage of your case. So taking into account also critical input from the expert may really be important, and you might need to adjust your strategy based on that. So for me, this is really a dialogue, trying to find the right expert that is really supporting your case, not because he or she is a hired gun, but because of the expert's real conviction and professional persuasion. So for me, one point is having, taking the time to do these conversations and find the person that is perfect for this case.
Thank you. Karl, bounce back on something I think you said in the previous panel, which is sometimes you select your expert at the same time, if not before, counsel.
Yeah, absolutely. And I mean, I would go even further than that and say that my approach to this is for the very long term. I know there's some who disagree with me and say you select an expert based on industry expertise. I don't agree. I think that you can teach industry expertise as long as you're looking sufficiently into the future. The same goes for lawyers, but it's especially true for experts. I may have chosen experts for a case I don't even know about 5 years from now. I may have chosen them 10 years ago, because I'm essentially teaching and we're growing together. The number one criteria you cannot teach, and which is the absolute criterion for me, is integrity. And I don't mean that in a general sense. I mean it in the sense of the example I previously gave, an expert whose conviction that the other side was right was so strong on a certain point that he would stand up to not just his client, but to the counsel who might be in a position to appoint him in other things that I have nothing to do with, and whose ultimate conviction was the key to essentially earning us the credibility with the tribunal to score a different, unrelated point because they saw our overall assessment as being credible. And so for me, it's a long-term project. It should never be done case by case. It should always be something that you're essentially grooming people for things you don't even know are going to exist years into the future and which you can't predict at that point when you begin to develop that relationship.
If I may, let me just echo, I absolutely agree 100% with Karl. And maybe I'll just sort of try to frame it a different way. A lot of people have this sort of naive view that when you appoint an expert, the question you have to ask yourself is, how well will he or she be under cross-examination? Well, how well an expert will be on cross-examination is not a matter of technique or personality. It's a matter of, is their report defensible to start with? And can they defend it? And so you want an expert who's going to stand up to you. If an expert agrees, if I'm interviewing an expert and he or she agrees with everything I say, I'm worried at that point. Because I want the pushback. I want to know when I'm overreaching, because I know at that point it's not going to be defensible. And as much as the expert may adopt a theory that I might offer, if he or she can't defend it on cross-examination, credibility is shot. I had this one expert relative in the last couple of years, and he was being cross-examined. And during the course of cross-examination, the cross-examining lawyer pointed out some mathematical error and, aggressively asked, he'd been gearing up for this, isn't this wrong? And the expert just calmly looked at it and looked up and said, oh, yeah, you're right, it's wrong. And it was a mathematical error that actually made very, very little difference. But because he gave it up so quickly, without fighting, carefully analyzing the report, it just elevated his credibility in the eyes of the tribunal. You could just see it. Everything he said from then on was believable.
Thank you, John. Thank you, everyone. I think we have used up all of our time. I think it was very interesting. Thank you. And apologies to the delegates whose questions we didn't have time to answer.
So first and foremost, thank you all, starting with everybody that participated and stayed with us throughout the entire afternoon in my time. I'm hoping that is due to the interest in the topic. Thank you to GAR for organizing the event, which I think worked very smoothly. despite the number of participants. And especially thank you to the moderators and panelists for their insightful and lively discussions and moderations. I think we've learned a lot and heard a lot. If I may summarize my observations, I think there's a common theme between arbitrators, counsel, and experts that there's still room for improvement when it comes to damages. And I understand specifically the users to say that damages is of a very high importance to them. So if we are acting and working to the benefit of our users and ultimately the people that make use of arbitration, then I think it's really time to start exploring new ways to assess damages and work jointly on damages throughout the entire proceedings, as we've heard, starting already at the procedural orders sessions or in the post-hearing events. And it may also be time to think about how to make best use of experts during the oral hearings and post-oral hearings, and in how and to what extent that may involve interaction with the arbitral tribunal, we will see. But certainly, I would like to conclude asking each and every one of you to become part of this process, and potentially we can work jointly on this in this forum to make it one of the areas in which these future developments are created. And potentially there's a next generation of arbitration proceedings that origin from these events. And I think that would be wonderful. John, if you may want to add.
Yeah, just let me add to that I want to thank the participants as well. And I think what made today's event successful was preparation for the event. And I think that's one of the themes that I heard throughout as to what makes assessment of damages successful in arbitration is preparation. And a few themes as well. We heard from the various users frustrations with the process, and I think optimism for potential solutions. I think the fact that arbitration offers flexibility gives us hope that the procedures can be adapted to the particular circumstances in a case. One size doesn't fit all in arbitration, particularly when it comes to what works for damages. And I think some of the frustrations are on what the proper role of the various users in the process might be. We need numerate counsel who can understand the damages issues, who can clearly communicate those issues to a tribunal and with credibility. We heard we need experts who can communicate with clarity, simplicity, and credibility to a tribunal. We've heard that we want arbitrators who are prepared on damages issues and who can manage the quantum issues and understand them, and are willing to ask questions when they don't understand. And I think, as Alexander said, this is a joint process. To make an arbitration work successfully, the different players need to cooperate together. And I think some of the frustration is when counsel or experts are not fully cooperative, and that can lead to negative results and also to a loss of credibility. So I think some of these issues overlap there. And I think the last point I would note, beyond preparation, management, and effective communication, is that the participants should be thinking about what the ultimate objective is. It's to, from a party's perspective, we're trying to communicate to a tribunal to persuade the tribunal, but we need to think from the arbitrator's perspective. What is it that they want? How can we work together to achieve that? And I took particular note of several comments that arbitrators are looking for commercial, reasonable results. And so I think we need to think in light of do the arguments that the parties are putting forward make commercial sense. And so I think with those remarks, I'd ask whether David has any concluding comments from GAR, if he'd like to share. And otherwise, if not, I think we go into a final networking session that GAR will organize, presumably along the lines of the last one.
Thank you both. Very quick remarks from me. I thought that was an absolutely magnificent edition of that event. So well done, everybody, including you, the audience, for joining in as you did. It really, really jumped, didn't it? A quick thanks to the two chairs for the ideas and setting it up in the first place and marshalling everybody so fantastically. The speakers, of course, but particularly the moderators, who I thought had really exceeded themselves this time and took every session to exactly where I was hoping it would go. And I'm sure that other members of the audience felt the same. We are going into networking rooms. We hope you can stay, some of you. It will be as it was before. If we can have slightly longer in the rooms, we will organize that. I will email our colleagues just to give us a few moments longer than sometimes we have. Before you go in, you will see a pop-up form. It's a single question asking you to give feedback on the event, whether you enjoyed it. Please take a moment to click something or other. And otherwise, that is it from us until the next time. Stay well, stay safe, and hope to see some of you in networking soon.